The big to mention about the two RSAs below the family pension matters. Lordship had actually fixed them on 10th of June as the first item. Bench did not say, if any date may be fixed, Manoj. So it's
After vacation.
any date, Manoj, I will give the mention.
I can't fix it. Isn't it parted?
It's a part heard. So the registry is not able
So you tell the court, the registry. I'll tell the registry of that. The question of mentioning item one, not purpose.
Any instruction from the bench assistant, perhaps.
It after vacation lagai dibo. We will give the number.
Lordship may indicate the date, perhaps.
After vacation, they will fix a date. Mr. Bijgoy, what has happened in this case is this. Initially, if you see the contents of the repetition, the move was to fix a payroll for all the states.
Initially.
That was the thing, and there cannot be only for the payroll for the principal seat. It cannot be. It has to be for everybody. So this was going on. The taken up matter was also taken.
Yes.
Where all the advocate generals appeared.
Yes.
And they say they made these submissions out there that okay, we will talk it out and do the needful. Now, thereafter, as the matter was stagnating with the state government of Assam, the Principal Seat Employees Association filed a writ petition 1725, which led to the PSP and the disposal of by the judgment dated 6/4/2017. But it was completely forgotten what will happen to the outlying benches. Then you have the appeal which has been filed. After the appeal has been filed, the appellate court also says about this thing to look into that. But again made it centric to the state of Assam. Thereupon the case comes up, contempt. Supreme Court directs them to file a writ petition before this court with the direction to complete it within 6 months. 2023, this matter has been filed. Now, on the last occasion when I said that I will pass an order taking into account the judgment of the West Bengal judgment as well as the Himachal judgment, it came to the attention of this court that how is it only you have to fix only the state governments of Assam. At the end of the day, if you see, there is one judgment of the Supreme Court. The Supreme Court makes it clear that the state government cannot fix the payrolls for the employees of the Guwahati High Court. Or even any High Court. Even for the Supreme Court also, the central government cannot fix. It is only the Chief Justice of the Supreme Court under 146(2) or the High Court under 229(2) who can do it. Now, what are the considerations to be taken? Like you have a pay commission. Just for example, this judgment, which State of Maharashtra and Association of Court Stenos PAs reported in 2002 to SEC 141. Now, every 10 years, you have a pay commission.
Yes.
And in the pay commission, what do you take into consideration? You take into consideration what are what type of work these people do,
Nature of government.
what type of endurement they have to face, their representations, what are the benefits, certain aspects which you take into account while again refixing. Just for example, in 2017, you came up with that ROP rules, 17/3/2017. Again in 2019, you modified the fitment factor.
Right.
These have been done taking into account the further representations and all.
Right.
Now the representations to be submitted on behalf of the state government, on behalf of the Guwahati High Court Employees Association or any employees of the Guwahati High Court cannot be taken into account by the pay commission.
Cannot be, yes.
So how it is to be worked out, which employee is to be given how much pay, is absolutely within the domain of the Chief Justice. This is what is the judgment of the Supreme Court. There's no quarrel with that
Yes.
proposition. Now, if that be so, it is the Chief Justice who has to do it. By taking into consideration the parameters which the pay commission also applies. Just for example, the pay commission applies various parameters when they go for refixation. Now you are going to have the 8 pay commission or the 7 pay commission. There are various parameters which are to be looked into. That in certain cases, this particular person may not get this amount, but this is what it is. So therefore, there is already a pay commission done in 2013 by the year.
Well.
Now, this has not seen the day, taking into account there is no approval either from, because you cannot have the approval only from the governor of Assam. Here, you have to have the approval from all the 4 governors. Isn't it?
Yes. To make it applicable in.
Yes, otherwise you cannot.
Yes,
And more particularly, you have to take note of that part 6 states about the state legislature. 1 legislature for each state. Whereas 216, which is in parts 5, says about 1 high court for 1 state, but 231 gives the power to the central government to have more high court, a common high court for many states. And accordingly, we have a common high court for 4 states. So therefore, this entire thing exercise has to be done in that manner. Although in this case, we do not have, there is already a pay commission rules or whatever may be, it is not for this court to fix the pay scale. I cannot under 226. The power is reserved for the Chief Justice to do under 229. And the Chief Justice on the administrative side has to take it up with the state governments. So therefore, the committee which is to be formed, one has to also understand the committee which was formed by the first judgment of West Bengal was on account of that there was no pay commission.
That's it.
And therefore there was a pay commission formed.
That's it.
In the judgment of Himachal, there is a pay commission being formed by which it is to be done. Now, what is required out here is tracing out the issues on the administrative side by the state government, by the 4 state governments with the Chief Justice. So therefore, my order has to be in that manner that I request the Chief Justice to form a committee whereby he would be in a position to trace out whatever issues are there. Because at the end of the day, there has to be a payroll. There has to be a pension. Now, what we are having is we are borrowing it. Now, the difference which is being happening out here between the state of Assam and state of Arunachal Pradesh is that they are applying the central pay.
Yes.
You are applying the state pay. You are saying that the state pay which is being given to them is on the basis of all other employees of the state government is also getting the same. Plus, we are also giving a PSP addition. You are saying. Now, for the state of Kohima and Mizoram, there is no PSP.
Yes. I understand that.
And therefore, there are some litigations from where it is also happening as regards the pay that the people out here in the principal seat is getting more from the people who are getting out there in Mizoram and in Kohima. Like here, we have a problem in here. Now the pension, what we are doing is we are getting the pension done from the Assam pension rules. Whereas the pension in respect to the others, state of Arunachal Pradesh is the central pays. So therefore, there is this ambiguity which is there in the rules has to be traced out and taken into consideration.
Disparity.
It will keep on having.
Final.
Because the question of the petitioners claim that they should be given similar pay scale like in Itanagar cannot happen unless you have a uniform pay. And that was the basic intention in 1989, why you should go for a uniform pay. So although the state of Arunachal Pradesh or state of AI is not a major party, but taking into account that this court is taking up this matter, I request the Chief Justice to form a committee whereby he will like to trace out all the issues as regards vis-a-vis all the states. So there might be a question out there. Now you are saying about the PSP. Now the PSP, your basic idea is that you have given a PSP and as such the question of further giving it is not the question of a financial crunch. That is why the Supreme Court in that judgment held it. But it is not the question of a financial crunch. It is the question of what is required to given by the state, by the what is the rules framed by the central government, by the Chief Justice. And you have to respect that, taking into account that, unless it is so that it is beyond the financial capability. Because in this judgment also, I'll read this paragraph. What are the things which is required to be taken? The Chief Justice the Supreme Court says, the court also expressed the view in the aforesaid case that the Chief Justice of India is the appropriate authority to consider the question as to the distinctive nature and the personality of the employees of the Supreme Court, and before laying down the pay scales of the employees, it may be necessary to ascertain the job contents of various categories of employees and the nature of duties which are to be performed. Further, at the time of preparing the rules for prescribing the conditions of service, including the fixation of pay rules, the Chief Justice of India will consider the representations and suggestions of different categories of employees of the Supreme Court, also keeping in view the financial liability of the government. You got it? It is in paragraph 5. So these are the aspects which are required to be taken into consideration by the Chief Justice at the time of framing of the rules. It cannot be only on the basis of whatever the Chief Justice wants to know. They also have to see as to the regards the financial liability of the state government, what will befall upon them. So therefore, there has to be a uniform. So my therefore direction would be that the Chief Justice should now trace out this issue with all the states.
By May, my lord. So far as my lord, some rules, my lord, in the process may have a High Court rule. I have found that, my lord, the applicability of the rule is mentioned in every rules, my lord, that has been framed, my lord, under 229. Like, my lord, the Guwahati High Court allotment of quarters to the private secretary rules 2021. There, the rule 2 says applicability. This rule shall be applicable to the private secretaries working at the principal seat of Guwahati High Court for the quarters constructed in and around Guwahati. Here, my lord, the principal seat has been defined. Now, in the rule, my lord, there are other rules also. I've checked, my lord, their applicability says it is the Guwahati High Court. It will apply to Guwahati High Court. Moment it says Guwahati High Court, all 4 will come.
Now you kindly see Rule 18 of the service rules.
Fine.
No, that book.
Well,
Yes. Rule 18.
well. Regarding vacancies. Vacancies in the higher grades of ministerial staff shall be filled according to merit ordinarily by promotion from prevention. Lordship is saying about the 1967 rules.
Now 17. 17A.
Yes, an employee in the service of the High Court, including those in benches of Kohima, Imphal, and Agartala, may be transferred from one station to the other in the exigencies of public services, and such transfer in the case of gazette officers shall be notified in the official gazette.
So therefore, all these employees
Otherwise, yes, they can be
comes within the ambit of this, because otherwise, if we say
transferred.
that these rules shall not apply to the other states,
I know.
other principles, then it will have a big problem for the High Court and the administrative side.
Yes.
So therefore, in my judgment, there is another judgment which I have rendered in the case of Guwahati High Court Principal Employees Association. The issue was as to whether the register establishment, which is being fixed out here, could have been brought by any person from any other year. So I have held it that it can be. And I don't think there is any appeal filed there against. So therefore, that has attained finality. So therefore, this is one rule which is being given out there. So the question therefore is that the Chief Justice has to trash out. Now in the judgment which you have referred to, in the second judgment of the West Bengal,
Yes.
it's very interesting to take note of that after the directions given in the first judgment, the Chief Justice along with the government have duly taken note of it and thereupon trashed out the issues. And there is a consensus arrived at that paragraph 3 of the paragraph 2 of Rule 4 should not be applied.
Only one was disputed.
That was not applied. The High Court Employees Association out there filed that this should have been accepted. And the Supreme Court says that no, taking into account that on the administrative side they have agreed to, there is no question of that being applied.
No.
But on respect to all others,
Yes, all are accepted.
and you also see the last paragraph of that very judgment, the very interesting observation.
Rule 4, second part of Rule 4. In all issues, as all issues have now been sorted out, the state government will, as agreed by it, now forward the modified draft pay rules, excluding the second part para of Rule 4 to the governor for his approval. In view of the assurance made on behalf of the state government to give approval to the modified draft pay rules, we find no need to issue any mandamus. As the matter has been pending for long, we are sure that the state will act with expedition so that the modified draft rules will come into force without any delay, and the employees of the High Court will get all their dues in accordance with the said rules. With this observation.
So therefore, when there was a consensus, as there was only a challenge that was not approved, now the state government says that we are going to give that approval. So that is one. Now, secondly, in this case, I think the petitioner should file an application making the other states a party. Although I am passing this order, but in the meantime, you file an application. Because this will be required at the end of the day, because other states have to be also brought in out here. Mr. Monto, that is
they have to take partition from the other state also. They will have
So the
independent-
approval cannot be only squad the state of
Yes.
Assam.
Correct.
Although I have interfered with, I will be interfering with that order on the basis of that they have declined the request on the ground of financial crunch. That cannot be the reason. The reason has to be separate, taking into account that they have to look into out there and find out that the justification which has been given in terms with that judgment which I have said,
Yes.
that the Chief Justice justification that these are the things which have to be taken into consideration. Because the employees of the Guwahati High Court do not have any avenues to place it before the pay commission.
Yes. They know him.
So they have no avenues. And in fact, when the matter went to the full bench, the full bench was informed initially that the Assam Pay Commission was looking into this aspect. Then the Pay Commission later on said that in view of 229(2), and as the Chief Justice have not authorized us, we are therefore not looking into it. And therefore you see in the rules itself, the ROP rules of 2017 itself, it does not apply to two categories. One, the judicial service officers, as well as those who come under the High Court.
Before going to the person, the rule, my lord, they have a conscious, if there is a conscious decision taken by all the statement, and it will be be there, so that they can, after my lord.
I have,
send it.
Mr. Gogoi, I have serious doubt as regards whether the earlier amount will be payable or not. This I have doubt. But for what is happening, 77 years have passed by and the High Court does not have a pay rule. It is shameful. So there has to be a pay rule. And there has to be a constant revision of the pay rule after every 10 years, as has been done. Otherwise, there will be a disparity. So every time they will
Rule is a
either
2013 rule. It is the rule which was placed, just I refused, the 2013 rule.
no, they are a 2013 rule, but the fact that the rule has not been the process in which it should be going has not been done. The High Court is only bothered with the state of Assam, but is not concerned what as regards the other states. So other states have also to be taken into account, more particularly in view of that judgment of the Supreme Court rendered by Justice Dipankar Datta on the question of transfer, as to whether a transfer is permissible by the judge, by a judge sitting out there in the principal seat of a matter from Kohima to Guwahati. The Supreme Court said that yes, it is permissible, taking into account that it is one High Court. So taking that analogy, one has to do it. Anyways, I'll pass that order to the defense.
It is giving the matter always pending, madam.
Oh,
Is
yes.
that report will be placed and finally.
In the meantime, my lord, other state have to.
Other states, they will make
Will
the
file an
parties.
improvement petition.
Other states, they will make parties. And in the meantime, they will file appropriate application. I'll keep the matter pending, but in the meantime, my direction is, I would not like the court to fix a commission, because the commission is already there. I'll only request the Chief Justice to form a committee by which they can trace out the issues so that and a report be submitted before this court. Then only things will be.
Right.
And as regards the PSP, yes, Mr. Patwari, you see, the finance department says that we are giving them the 7-pay commission along with the PSP. Now, if you see the judgment of Justice Bhuiyan, dated 6/4/2017 in 1754, it says that as an interim measure pending disposal of the pending finalization of the routes,
Absolutely correct.
the PSP is being given. So the PSP factor, we are giving them a PSP factor cannot be the reason for that because it is in the interim measure
Till finalization rule.
till finalization. So therefore the PSP being given cannot be the reason for declining. They have to say that with this PSP, which is being given, that they may say that with this PSP being given, the amount having gone up, so therefore we accept the rate at this, not the PSP.
There is a notification, it says that, my lord, the basic pay will be the scale pay plus grade
This
plus
is
PSP. The grade
no,
pay
Mr.
plus- it will be
Mr.
the
Gogoi,
basic
you
pay.
have to understand that notification of 16/8/2016
Not-
came out of an order passed on 4/4/2016 in WPC number 1754,
not-
wherein it has been given, and this is pursuant to a discussion having taken place in November 2015 with the, what you call that, Commissioner and Secretary Finance Department, who now happens to be your Chief Secretary, wherein he categorically stated that we will include the PSP into the basic pay. And therefore, the 4/4/2016 came into the being.
Right.
Now, but this is an interim measurement till finalization.
Other than that order is there. Pending.
So, because there is, let us take the simple analogy, because there being an interim order being passed, are you saying that the final relief should be guided by the interim relief? It can't be so. So therefore, the PSP factor, you have to come up, okay, as we are giving this PSP, which comes to this amount, and therefore the scale of pay would be this amount which we approve. That is a different aspect. But you cannot say because of the PSP we are declining. I'll pass the order. I have in fact dictated the order. It has gone long, out of 48 pages. But you make that. Huh?
I will immediately file the implementation.
That is why I fixed the matter today, so that I can tell you that this is what is the reason why I had to, because this was not what was discussed on the last date.
Section 2 of the impugn rule has to be amended because the rules say it will be applicable to the High Court, but the rule 2 say it will be applicable to the principalship. That part,
Which one?
the impugn rule,
Ah,
The applicability, there is a provision.
applicability, it was has to be amended.
Yes, if you-
At page 312 of the additional affidavit, running page 312.
Rule number 2. Rule
no,
number
these rules have to be amended.
This
312. It cannot be only for the principal
Yes.
seat.
rule 2 has to be.
This rule
Otherwise,
2 has to be amended because
Rule 1 is okay.
because why the government is only taking into account the state, isn't it? See, kindly come to page 312.
Rule 1 is okay, rule 2 has to be.
If it is the High Court of all states, why you are having a rule for the principal seat only and not for others? This will create a disparity. And in fact, if you see, kindly come to the writ petition. Kindly come to Annexure B.
As well as outline.
Yes, this is the mandate.
So then that way, my lord, so my lord, so that is confined only to the principal.
Yes, therefore it is this is the basis on which it has been made,
Principal seat as well as outline.
outlined. And this is the reason why, if you see the earlier one, it was resolved.
Page 67 to my lord, subject. 67.
Kindly come to page 46. Representation of the High Court Employees Federation dated so and so regarding uniformity in the pay structure, recruitment rules and nomenclature of the High Court employees throughout India. Deleted. This item shall be taken up by the respective Chief Justice of the High Court with the state government. So on that basis, you have this particular thing.
Like, my lord, rule 2 at page 3132 has to be amended and outline benches has to be incorporated.
No, it has to be. Now, in fact, you see page 54. See the introduction. These are representations received from all states, from all the benches. Maybe because of the matter being pending out here, these officers may not be aware of that. But the fact remains that it is the rule for everybody. You cannot have the rule only for the principal seat. Now, this is the fixation. Now, interestingly, what about the pension? Mr. Monto, you see, 229(2) says not only all terms and conditions, including pension, emoluments, salaries, as well as there's another one. Huh? No. 229(2) says something there.
Allowance, salaries, allowances, leave or pension.
Leave or pension. So therefore, for leave also, there has to be leave rules. Now, why it is only done for the purpose of pay? How do you, therefore you have to say somewhere in your rules that leave you borrow it from somewhere and thereby incorporate it by legislation, by incorporation. Don't you think so? Pension also, you have to incorporate it somewhere. So we direct this, but I think you should make the states as well as the employees association of the other three. You make them parties because they may have tomorrow, if the High Court says in the other three states, there's no, these Assam and other two states may not be a problem. But as regards the CCS, wherever the CCS applies, there they may have a problem taking into account that their rights should be taken away. So therefore, you have to make that association a part. The matter have been heard and heard, comma. No matter has been. I'll pass it in that disorder itself that you make these associations and all that.
deeply.
What is the CRP?
This is regarding the equaling the compromise.
Huh?
Petition melody for equaling the compromise.
That power of attorney holder.
Power of attorney holder may can compromise agreement filed before the court melody and suit was decreed on the basis of the compromise. We filed a petition for equaling that.
Calling?
Recalling the said order melody, order 23.
But you have not taken your action against your power of attorney. You have not.
This power man, he has not now acting on the basis of the now. So in as and when it is necessary, my lord,
File a suit. Or you cannot file a suit.
cannot file a suit, my lord, cannot file a suit, we cannot file an appeal, my lord. So only remedy is
151.
no, my lord, under proviso 23.
No. 151 only.
No, my lord.
The judgment of the Supreme Court is very clear. Even the latest judgment by Justice Dhulia is also clear on that.
My lord, in the judgment, my lord, there is on Banaris, my lord, regarding the maintainability of that petition is settled, my lord, because earlier they have raised the objection whether we can file a appeal or a petition, my lord. But subsequently they have admitted that this petition is maintainable, our petition, because ultimately, my lord, it is held by the apex court that the petitioner, my lord, have two options. Either he can file an appeal under order 23 rule 1A, my lord.
Under?
Under order.
Order?
Order 43 rule 1A, my lord. Because order 43, my lord, earlier there is a 1M, my lord, that was deleted, my lord. Subsequently there is, my lord, order 43 rule 1A, my lord.
1A.
A, yes, my lord.
Right to challenge non-appealable orders in appeals against decrees. Where any order is made under this code against a party, and thereupon any judgment is pronounced against such party, and a decree is drawn up, such party may, in an appeal against the decree, contend that such order should not have been made and the judgment should not have been pronounced. In an appeal against you bring in order 43 rule 1A to having a right of appeal?
My lord,
That's not a right of appeal.
so we have not filed the appeal, my lord. We have filed. We
No,
have filed a
order,
peti-
you see, order 43 rule 1 says about the orders which can be appealed.
Yes, ma'am.
Okay. Order 43 rule 1A,
Yes, ma'am.
1 relates to, just for example, you file a condonation application. That condonation application is dismissed, which results in a non-appealable order,
Yes, ma'am.
and the consequential result is that the appeal is dismissed, thereby confirming a decree, and therefore you have a right to file an appeal, which is a regular appeal under section 100 or 96.
There is a compromise decree, my lord. So 96 3, my lord, there is a bar, there is a compromise on the basis of that compromise, the decree is passed, it is barred for any appeal. So, my lord,
The only way is 141, 151.
not on the 51, order 23
subsection 3 million proviso. Proviso is there.
What does it say? Provided that where it is alleged by one party and denied by the other party that an adjustment or satisfaction has been arrived at, the court shall decide the question, but no adjournment shall be granted for the purpose of deciding the question unless the court, for reasons to be recorded, think fit to grant such adjournment. How is that relevant?
Because we have challenged the compromise.
The compromise you cannot challenge. You can only challenge the compromise under 151. But be that as it may, we will construe your petition under Order 3023, Rule 1A to be a petition under 151. Now, therefore, to tell me, you did not adduce evidence. So how do you prove the proof? Matter ends there. Matter over. How can you allege fraud?
The power, my lord, on the basis of the power, on the basis of the special power attorney, my lord, there is no any provisions for allowed him to make any compromise. There is specific provision, my lord,
Where is the power of attorney?
that man page 60, my lord,
Page?
page 60, my lord. And this is a special property, not general property.
What is it there in the name? A rose is a rose.
Can be the rule is, my lord. Can be also.
You did not, nobody contested on the court fee being, the stamp duty being less. To file petition, written statement, evidence on affidavit, face crossing, take all steps in the suit as well as other proceedings, take all steps. Matter over.
Process take all steps.
Enough, we dismiss your petition now. Heard Mr. P.S. Dekar, the learned senior counsel. Mr. Dekar, I have heard you many times. It is shameful for this court to listen to you any further. I gave you an opportunity long time back. Think about adducing evidence out there. Something that you are the lawyer out there did not advise you properly, but you failed to do so. How can I help you?
Yesterday, so it is not listed.
Not necessary. If it is not listed, I don't take into consideration.
By power of the honorable court, it allow us to adduce evidence to that effect only, my lord. But regarding, my lord, other my lord will suffer, my lord, because we have also filed counterclaim. We have also sought for a declaration of right title interest on the basis of our wrong possession, my lord. So, but my lord, in the compromise, my lord, nothing has been made, my lord, in the compromise petition. Not a, my lord, in the trial court, my lord, he even did not examine the power of attorney holder both sides.
Why is it required?
Even the satisfaction must be by the court who.
Court is satisfied.
Examine, my lord, examine.
Not
Examine.
Examine. They both they appeared. The court has finding its positive findings for
The court has
satisfaction.
mentioned out there.
Yes,
and
yes.
it has appeared.
Yes, yes.
I remember, where's that order?
No evidence, my lord, taken.
No.
There evidence.
Evidence
78.
taken means you have to deduce
Page
evidence.
70, my lord, can be evidence.
No.
Page
At the
78.
preliminary,
No. The attorney holder for the AI, three so and for Iman are present along with their respective counsels. Over.
so their statement, whether they are.
Next
they would
para, my lord,
nothing,
kindly have.
Only oral, my lord. Their statement should have been reduced in writing, my lord.
Where is it mentioned?
There is, my lord.
Where is it written? Any law show me that?
This
How it
satisfaction-
is so, it is not required. Tomorrow we may very well say, when if I have another person out there and ask him a particular question, then I have to again take an evidence.
this
Mr. Dekar, and I think that you can make a submission, but don't make it so far-fetched. Okay, we dismiss it.
Another-
No point.
the
There's a stay? Stay going on?
No.
mostly.
Then what is there?
The execution will not carry forward the execution.
You go ahead with the execution. I'll keep the matter pending. I'll give it very clear that you go ahead with the execution and let it be decreed. After decreed, the matter be listed before this court.
Right.
Chalo. No, I will give you further opportunity, but let the execution continue and be finished, and thereupon the matter be listed.
They will have to pay me, Lord.
I will, we will pay.
No,
We
they are
will pay.
ready
That is
to
a
pay.
part of the compromise decree.
Then again, my Lord, okay, my Lord, if you want to pay.
We will pay them 42 lakhs.
So you are saying, okay, so he will pay and matter we close it.
It's a part of the
Huh?
Power of holder who execute the compromise, my Lord. He will accept, my Lord, because we will not accept. Meantime, we may cancel his power of attorney also, then he.
You cannot cancel after it has been done. Mr. Deka, kindly don't make this type of submission.
When the compromise petition filed, at that time also the power of attorney not cancelled.
Then you did not cancel this. At any point of time, this day you are not taking action against them. What is this? Chalo, this is a case for dismissal right away. Now, heard Mr. P.S. Deka assisted by so-and-so appearing on behalf of the petitioner. Petitioners. Behalf of the petitioners, Mr. B. Dotto, the learned senior counsel, assisted by S. Deka, who appears on, huh?
125.
Appears on behalf of respondent number 125. Mr. So-and-so, who appears on behalf of the respondent number performer or respondent number 6. So-and-so, who appears for the respondent number 7. The revisional jurisdiction of this court has been invoked, challenging an order dated 5/2/2024, passed in Mizze case number 49/2023, arising out of title suit number 36/2019, as well as the on the ground that the compromise judgment, compromise decree so recorded by the learned trial court, that is the court of the, what is that? Civil Judge Tinsukia.
Senior division.
Huh?
Civil judge, senior division,
Tinsukia. Compromise decree
7/7.
dated 7/7/2022. Passed by the, made by the learned court of the civil judge, senior division Tinsukia, in title suit number 36/2019. Was illegal and fraudulent. The question arises before this court is as to whether the learned trial court, that is the court of the so-and-so, was justified in rejecting the application filed for recalling of the compromise decree by the order dated 5/2/2024, passed in Ms. case number 49/2023. Full stop. Taking into account that this court is exercising the power of revision, comma, the jurisdiction of this court is limited to see as to whether the learned trial court had exercised the jurisdiction, had committed any error in exercise of its jurisdiction, or had exercised the jurisdiction illegally and with material irregularity. To ascertain the said aspect of the matter, this court finds it relevant to take note of the brief facts which led to the filing of the present proceedings. Full stop. Where is the suit? Full stop. The respondent numbers 1 to 5 had instituted a suit being title suit number 36/2019 against the petitioners herein seeking a declaration of their right, title, and interest of the right, title, and interest of the plaintiff number 1 in respect to the Schedule A land, plaintiff number 2 in respect to the Schedule B land, plaintiff number 3 in respect to the Schedule C land, and the plaintiff number 4 and 5 in respect to the Schedule D land, semicolon, for recovery of the vacant and cast possession of the Schedule A, B, C, and D land by dismantling and removing the unauthorizedly and illegal constructions made by the defendants after evicting the defendants, their dependents, etc., and for permanent injunction. The said suit was registered and numbered as title suit number 36/2019. The defendants joined together and filed a written statement cum counterclaim. The counterclaim filed by the defendant in true sense was not a counterclaim. The counterclaim filed by the defendants was seeking declaration that the sale deed numbers 1325 dated 29/7/2013, semicolon, sale deed number 1326 dated 29/7/2013, semicolon, sale deed number 1369 dated 8/2/2013, and sale deed number 1371 dated 2/8/2013 were null and void and unenforceable in law, and for cancellation of the mutations so made on the basis of the said deeds of sale, semicolon, for a declaration of the rights of the right, title, and interest of the defendants, numbers 1 to 9, oblique the counterclaimants over the Schedule A, B, C, and D land, for cancellation of the mutations, etc. It is relevant to take note of that the said written statement as well as the counterclaim was filed on behalf of the defendants it is relevant to take note of that the said written statement cum counterclaim as well as the counterclaim of the defendants were filed on the basis of an affidavit on the basis of verification and affidavit signed by Sri Rajesh Urang, who was the defendant number 1 in the said suit.
He is the power of it.
First, this court further finds it relevant to take note of that on the date of filing of the written statement, come counterclaim by the defendants, comma, the defendant numbers 2 to 6 2 to 7 had executed a special power of attorney on the same date, that is on 17/8/2019, empowering the defendant number 1 to carry out empowering the defendant number 1 with the following powers, which is reproduced herein under page 61 of a 1, 2, 3, and 4 are generally লিখে দিব 1 to 4 are generally. The suit thereupon continued on 7/7/2022. The plaintiffs as well as the defendants filed a joint compromise petition before the learned trial court, which was registered and numbered as petition number 23402/22. On behalf of the plaintiff, the plaintiff number one plaintiff number the power of attorney of the plaintiff signed the said comma and verified the contents of the said joint compromise petition, and on behalf of the defendant number one, for himself as well as power of attorney holders of the defendant number 2 to 7, had signed and verified the contents of the joint compromise petition. The supporting affidavits to the said joint compromise petition were filed by the power of attorney holder of the plaintiffs, as well as by the defendant number 1, and on his behalf, and on behalf of the defendant number 2 to 7 by the defendant number 1, who was their power of attorney. First, a perusal of the said joint compromise petition shows that both the plaintiff and the defendants have entered into a compromise containing various terms and conditions, which are enumerated in paragraph number 3 of the said joint compromise petition. First, the said paragraph number 3 of the said joint compromise petition being relevant is reproduced here in under. Etu 3, eta 3 eta ase, etu 3 to gondogulia 3, and main 3 to divo, page 73 tase. Apa 3, Roman 1, 2, 7 all ase. On the very date on which the said compromise petition was filed, that is on 7/7/2022, the learned trial court, upon taking into account that the power of attorney holders of both the parties were duly represented, including the defendant number 1, disposed of the suit on compromise by incorporating the terms and conditions so agreed upon in the joint compromise petition to the compromise decree. Further to that, the compromise petition containing the terms and conditions of the compromise was marked with the letter X and made a part of the decree. First. Six months thereafter, around 9 months thereafter, the defendant numbers 2 to 7, 2, 3, 4, 5, 6, 2 to 6, who are the petitioners herein, filed an application for recalling the compromise decree. By the petition, which was compromise decree, which was registered and numbered as case number 49/2023. It was the allegation made in the said application that On 3/3/2023, certain police personnel came and entered the suit land and started measuring the suit land. It was further stated that the petitioners who were the applicants, it was further said that the petitioners resisted them from measuring the land. The petitioners thereupon inquired and came to learn that the suit was decreed on compromise on 7/7/2022 and that the defendants in the suit had waived their rights over their claim over the schedule A, B, C, and D land on the basis of an amount of rupees 42 lakhs, which was yet to be paid to the petitioners, isn't it? Have not been paid to petitioners. It was further mentioned that the defendant number 1 never had taken the contents of the consent of the petitioners to waive their rights and interests over the suit land. And as such, the judgment and decree dated 7/7/2022, on the basis of which the title suit number, the judgment, and as such, the compromise decree dated 7/7/2022, on the basis of which title suit number 36/2019 was disposed of, was fraudulently done behind the back of the petitioners. You filed objection?
We have not filed objection, we participate in the hearing.
So wouldn't it be deemed that whatever they are saying is correct when you have not on the doctrine of non-reverse?
No, we participated in the audit hearing and.
But these are allegations of fraud. You have not.
Allegation of fraud against us. Is a question of only the allegation against their power of attorney.
Whatever may be, but the allegation of fraud is there. You have not replied.
Written submission we have filed.
No, there cannot be a written submission. Why there was no reply?
No reply.
Ah, we allow the petition now. We set aside this because there is no reply. The court has made a mistake. These are allegations. No reply.
Basically, they have the entire allegation against their power of attorney.
So what?
But we are not representing the power of attorney holder. We are not representing the power. That is that. Therefore, we made our written submission. And
So isn't it they mentioned that there has to be some negotiation with somebody? With whom did you have a negotiation? To the power of attorney. So you have not made a statement to that effect.
No.
So therefore, without that being there, now whether the power of attorney was authorized or not.
See, my lord, that whether compromise decree passed by the court, whether is legally they arrived at a just and reasonable conclusion by the court itself.
But if you don't deny it, why do they have to give evidence?
Now the court has finds, my lord, that there was no allegation against the council because the council has also
endorsed the compromise petition. Court having a clear findings. Number one, there is no allegation against the counsels of the defendant.
I understand, Mr. Doctor, but the
I-
question is,
I
without your
understand.
reply,
I-
there is an allegation of fraud, you being not reply, you haven't replied to that, then how is it possible?
That's but otherwise also, the court's findings from paragraph number 53 to 73, my lord, came to a conclusion that the compromise arrived by the parties are lawful, and there was no allegation against the counsel, there was no revocation of the power of attorney, and my lord, uh,
How do you know? How does the court know about the revocation of power of attorney? They did not deduce evidence.
no, they did not say in the petition, my lord.
It is, if they don't say in the petition, does it imply that the court knows it?
There was no averment in the petition.
So
So therefore, the court says
the
that
court
there was-
could not have taken into account that because
That's
there is an allegation that we have never consented them and he has entered into.
that, my lord, we cannot can say anything that we have filed, my lord. But the court's findings, my lord, is very, very clear and very, very reasonable. So for my respectful submission.
What is the reasonableness without there being objection? They don't have to give
May I not
evidence.
say, my lord, subject to correction, may I not say that the objection to their application is necessary, not only. I'm not denying it, but it is also, if it is, if I'm disputing, that also made the attention of the court.
How?
Because our objection has
So
been
tomorrow we will say that orally it is being done, it is enough.
not necessarily, my lord, in all
No.
petition, the written objection is necessary. In
No,
all-
then it has to be absolutely on the point of law.
But the court only to see, my lord, that whether the compromise is entered into lawfully or not.
Very well.
That's the only thing.
But they categorically allege fraud.
Now they say their allegation.
Therefore, they did not deduce evidence.
Now they're saying only, my lord, that there was no allegation in their petition against the counsel, their counsel, because the counsel was engaged by all the petitioners hearing, my lord. They have not putting any single words against the counsel. And lordship is, I need not to explain to this, my lord, actually, that there is a series of judgment of the Supreme Court also, that if the counsel has himself entered into a compromise petition, engaged counsel, that's also valid in the eye of law. Or lordship is also. So there is a series of decisions, my lord.
There are
Then
many
even if not
there
signed
are
the
series
parties,
of
my lord.
decision against that also. There are series of judgment decision.
No, my lord, no, they are
Unless the council has the instructions on written, it cannot happen.
That's I understand, my lord. But my respectful submission, my lord, that the council, if there is no allegation against the council, then if the council has entered into a compromise petition on behalf of the parties, that is also binding effect upon the parties. So, but there was no allegation against the council, my lord, in that application finding for the plan. So that judgment ratio of the judgment of the Supreme Court also applies to this case.
Which judgment?
I don't know. Compilation, my lord, serial number 3, 4, 7.
Which one do you want to rely?
All are 3 in a column.
Page?
Page, my lord, 55. Paragraph 38 of the 1992 judgment.
55.
55, my lord. The running page 50. Paragraph 38. And 39.
Only come to 44.
44, my lord. Yes, no, not challenge. But even it challenge, my lord. Now, lordship kindly have a look at the next judgment also. Page 72, my lord. The last lines, my lord. Yes, page 73.
That is the same judgment earlier referred to.
Judicial. Not.
That's the same judgment you are referring to earlier.
No, this is the 92 judgment I am referring first. Now, I'm referring Guinness, I'm referring to Pushpa Devi, my lord, 4. Page 72, my lord. The 73 last two, 3 lines, my lord.
73.
73, lordship will find the taking into
Consequently, the
account.
statements
Yes.
of the parties or the council recorded
Yes.
by the court and
I-
duly
the both
signed
are
by the parties
attorney
making
holders
the
or-
statement in writing signed
By the authorized pleaders.
however has to satisfy in terms of the Iman. In this regard, we find that the trial court recorded.
Either of these. no.
Recording is something. Respect to the suit and we also find that the counsel for the plaintiff and counsel for the defendants made solemn statements on oath. Wait,
And that was, now in
then
2015.
you
judgment-
cannot.
No, the 2015 judgment, my lord, kindly see,
There.
is page 117, my lord.
Yes, this is the judgment which says that you have to file under 151. Paragraph 14. The application for exercise of powers under Rule 3 can be labeled under 151, but where the amending act itself such power has been vested in the court before which the compromise has been made, the power in the Iman has been exercised by it has been held by the different that even after compromise has been recorded, the court concerned can entertain application under 151, questioning the legality and validity of the compromise. As I said, this is the judgment, 93. And recently, Justice Dhulia has also.
Yes, Your Honor. That's
Yes.
it.
Now kindly come, yes, which is there? Paragraph,
Para, my lord, 2015, para 18, 19 and 20. No, I'm mistaken. 107, 95, page 95, my lord, I'm sorry. Two 2015, 5 SCC, 747, my lord. Paragraph 18, 19 and 20.
this cannot be because of the fact that the council did not sign. It has been signed by these two persons. Then,
Yes, as well as the council, my lord.
then,
Now my only contention, my lord, subject to correction, my lord, that they have not made a single statement against their council.
not
Their
technically.
council.
You see, the council may have acted against them, for them, whatever may be, I'm not on that. But it is not an affidavit on the basis of the council. It is an affidavit on behalf of the
On behalf
both the
of the-
power of attorney
yes,
holders.
Correct.
There's a serious allegation being made against the power of attorney holder, and you did not reply.
That's there.
So?
I cannot say no because I can.
So the case is of remand. Giving you an opportunity to file written statement.
Right.
And they will be giving evidence. What do you say?
Giving a time limit, my lord, because
Why?
this is up to this.
It's
I
because
leave
of
it
you.
to my lord.
It is because of your fault.
Councils, my lord, the fault of the council we are here. My lord. Sometimes the fault of the party we are here. Sometimes the fault on the part of the.
Therefore, it is seen from the records that the respondent numbers 1 to 5 did not file any written objection to the application filed for recalling the compromise decree. Full stop. The allegations of fraud which were made in the application filed by the petitioners remained unrebutted. Full stop. This court further finds it relevant to take note of that on the ground that the application so filed by the petitioners remain unrebutted, the respondent, the remanded, the petitioners also did not feel it necessary for adducing evidence in the said proceedings. First, be that as it may, at the time when the matter was taken up for the hearing, the respondents herein, who were the plaintiffs, objected to the said petition by submitting written objection, written arguments, as well as making oral submissions. First, this led to the passing of the impugned order dated 5/2/2024, by which Ms. case number 49/2023 was dismissed. Holding inter alia that the compromise decree so entered into by and between the petitioners herein as well as the respondent numbers 1 to 5 was lawful. First, in the backdrop of the above, the present proceedings have been initiated. First, Mr. P.S. Dekar, the learned senior counsel appearing on behalf of the petitioner, submitted that the petitioners were never informed by their power of attorney holder about the suit, about any negotiations with the plaintiffs. And further, as regards any settlement. First, it came out of the blue for the petitioners when on 3/3/2022, 3/3, na? Some people came to measure the suit land. And then on inquiries, it could be learned that the defendant number 1, who is the power of attorney holder of the petitioners, have behind the back of the petitioners, have entered into some sort of negotiation and compromise with the plaintiffs. the learned senior counsel further submitted that this aspect of the matter having that the plaintiff, that the respondents numbers 1 to 5 having no of the fraud so committed had also in their wisdom had not filed any written objection. And it is only at the stage of arguments they objected. He therefore submitted that the learned trial court ought to have allowed the said application on the ground of the doctrine of non-traverse and section 57, 57 of the Indian Evidence Act 1872 on the principle that facts admitted need not be proved. Per contra, anything more? Per contra, Mr. B. Dotto, the learned senior counsel, submitted that the scheme of the code would show that unless the compromise decree is not fraudulent, unless the compromise decree unless the compromise decree is not fraudulent and unlawful, comma, the question of interference with a compromise decree is not permissible by the court. First, he referred to the provision of section 96 of the code as well as the judgment of the Supreme Court in the case of SB Banwari Lal versus Chando Devi, reported in 1993 1 SCC 581, wherein the Supreme Court have been categorical that the question of interference with a compromise decree is not permissible, since an application under section 151 of the code. He therefore submitted that merely the pleadings in terms as he therefore submitted that pleadings cannot be construed as proof, being the well-settled principle of law, comma, the plaintiff, the defendants, the petitioners, under such circumstances, only on the basis of an averment made in the application, comma, cannot succeed without evidence being led under led, proving that the compromise decree is an fraudulent act on the part of the defendant number one in collusion with the plaintiff. He therefore submitted that as the averments made in the petition so filed being registered as Ms. J case number 49/2023 on the face of it was not sufficient, it was advised to the appellant, to the petition respondent numbers 1 to 5 herein, that there was no necessity of filing any written objection. He therefore submitted that the learned court below was justified in passing the order dated 5/2/2024, as there was no evidence adduced proving that there was any fraud committed by the defendant number one in collusion with the plaintiffs. Anything more? This court, having heard the learned counsels appearing on behalf of the petitioner, have given an anxious consideration to the materials on record. First, from the facts so narrated herein above, it would be seen that the defendant number one was duly authorized to act on behalf of the defendant numbers 2 to 7 in the title suit, being title suit number 36/2019, and further to take steps on their behalf. This aspect of the matter would be apparent from the perusal of the powers so given on the basis of the power of attorney dated 17/7/2019, 2022, 19. And on the basis of which both the written statement and the counterclaim was filed and was signed, verified, and filed by the defendant number one. First, it is further seen from the very order dated 7/7/2022 passed in the compromise petition, being petition number 3402/2022, that both the plaintiff was represented by their power of attorney agent, and on behalf of the defendants, the defendant number one, along with the defendant number 2 to 7, were duly represented through their power of attorney. The defendant number one for himself, and as power of attorney holder of the defendant number 2 to 7, have represented before the learned trial court. On the basis of the compromise petition, the learned trial court, assuming the learned trial court, after arriving at the conclusion that the compromise so entered into was lawful, had passed the compromise decree on 7/7/2022. First, it is further apparent that from the contents of the petition, application so filed by the petitioners herein, that behind the back of the petitioners, comma, the defendant number one had entered into some secret negotiation with the plaintiffs, and on the basis thereof had entered into the compromise, thereby giving away the rights, thereby waiving the rights of the defendant numbers 2 to 7 in respect to the suit land. These allegations are allegations pertaining to fraud committed by the defendant number one in collusion with the plaintiffs, and that too behind the back of the defendant numbers 2 to 7, who are the petitioners before the court. These allegations were required to be rebutted. But however, it appears that on account of the legal advice received by the petitioner respondents, herein who are the plaintiffs, there was no rebuttal by filing any written objection to such allegations. The non-rebuttal of these allegations, comma, also led to the presumption of the petitioners that there was no requirement of submitting any evidence, as the petitioners, as the plaintiffs did not deny to the allegations. This resulted in the petitioners herein, who were the defendant number 2 to 6 in the suit, not to file any evidence. The resultant effect is the order impugned in the proceedings, whereby the learned trial court, without taking into account, without the proof of the allegations, without the learned trial court, without considering that there was no rebuttal to the allegations, passed the order dated 5/2/2024. This court at this stage finds it very pertinent to take note of the submission of the learned senior counsel for the plaintiffs, to the effect that it was on account of the legal advice there was no rebuttal evidence, the rebuttal to the averments made in the petition, which was registered under as Ms. J case number 49/2023. He therefore submitted that on that basis, comma, the entire judgment and decree, the compromise decree, may not be set aside, as the same was otherwise lawful, as would be apparent from the very findings of the learned trial court. Taking into account the above, this court therefore disposes of the instant proceedings with the following observations and directions. Number one, the rejection of the application by the learned trial court by the impugned order dated 5/2/2024, comma, is in the learned trial court had committed an error, had illegally exercised the jurisdiction illegally and with material irregularity in rejecting the application being Ms. J case number 49/2023, without there being any rebuttal to the allegations contained in the said application. Accordingly, order dated 5/2/2024, passed in Ms. case number 49/2023, is set aside and quashed. Full stop. This court taking into number 2, this court taking into account that on account of an incorrect legal advice, the petitioners, the plaintiffs did not submit any written objection, gives an opportunity to the plaintiffs to file written objection to the averments to the application, being Ms. case number 49/2023. Full stop. This court, number 3. This court further also takes note of that on an assumption that as there was no written objection, the petitioners herein who were the defendant number 2 to 6 was not required to adduce evidence, permits upon filing of written objection contesting to the averments made in Ms. case number 49/2023 to adduce evidence. This is so necessary, taking into account that mere pleadings, cannot be said to be proof, and more so when the pleadings pertains to fraud. This court, in view of number 5, in view of the above, this court restores Ms. case number 49/2023 to the file of the learned court of the Civil Judge, Senior Division, Tinsukia. Full stop. Records have come? No records. Full stop. Taking into account that all the parties are represented before this court, they are directed to appear before the learned court of the Civil Judge, Senior Division, Tinsukia on 21st of July 2025, on which date the petitioner, the respondent numbers 1 to 5 herein, who are the plaintiff, would file their written objection if so advised. Full stop. Taking into account that it is a compromise decree, taking into account that the suit have already been, that the suit had already had ended in a compromise decree, and the question arises on the question of lawfulness of the said decree, this court would request the learned court of the Civil Judge, Senior Division to dispose of the said application at the earliest and preferably within 4 months from the date of appearance of the parties.
Yes, sir, ma'am.
I gave you a chance.
Happy. Mr. Good day for him.
Yes, what is this?
That is your look.
What? Who is the senior? Huh? Pertaining to what?
My
You
lord,
make your submission.
on account of her payment, my lord, during service period, a sum of rupees 1,80,000, 83,582 was recovered from area and future relief of the petitioner, my lord, which includes, my lord, rupees 20,935 from DCRG. They filed affidavit, my lord. They admitted the same, my lord. I have received
How much it has been recovered?
my lord, by Treasury Salon, my lord. 1,62,648, and from DCRG, my lord, 20,935, total, my lord, 1,83,583.
When did you retire?
My lord, on 31/12/2021, my lord.
After that? After you retired, they do this.
My lord,
Now, what is the ground? What is the ground for excess payment?
my lord, they say during my service period, the payment was, that payment was made excessively. And
Why?
My lord, I'm sorry, my lord.
What? You're sorry?
Reason, my lord, reason was not shown, my lord. I was not aware of the reason, my lord. I was not informed, my lord, the reasons for excess payment.
We have filed an affidavit yesterday, but it was lying defective because we could not serve copy to. Today morning I have served copy. Let it come any other date, Lord.
Why?
I have filed my affidavit.
You pay interest? Why on earth have you done it after? What was he working as?
UD assistant. We just followed the DDO. The DDO sent us along with the papers form 19. In form 19, he mentioned that there is an excess overdrawn of gratuity and leave salary, which total comes to 162,668. And there was also lordship 20,000 of gratuity overdrawn. He gave an undertaking that I have annexed to my affidavit. And in fact, he also paid back that he have annexed to his reputation, deposited to the treasury. So we followed that instruction, Lordship. Others, we have nothing to say. The administrative department, DDO had himself said, sent back in Form 19, these are the recovery. And he gave an undertaking that was also enclosed along with his all the particulars.
He had to give that undertaking because otherwise his pension papers would not
My
be
lord.
done.
My lord, in that
That is why
competitive-
you're putting a gun on his head and then you are asking him.
But he have done that, he is not.
But how do you take care of Rafiq Masih?
Traffic must see, Lordship, that's with all respect, that is not based on any, based on only on hardship, not based on
Huh?
not based on any legal principle, but only based on hardships. That is
Hardship,
what
we are
hardship.
concerned with hardship. And where Rafiq Masih categorically says in that particular paragraph that it shall not be equitable to take to recover in 4 circumstances. One is if a person is going to retire within 1 year. Here the person retired. After that you are doing it. You didn't inform
Yeah,
him before that.
Prior to, when papers were sent, that is it was shown.
No, he retired in 2021. When did he retire?
31/12/2021, my lord.
He retired in 21. Then how do you take care of Rafiq Masih? Give me a good idea. I have all sympathy for you.
The Chandi Prasad, Lordship, that case, wherein Supreme Court says that public money, Lordship, if one has to take, he has to pay back, Lordship.
That Chandi
Prasad, no,
Prasad is a judgment of 2 judges.
2 judges.
That in that case, they had taken into account BJ Akbara and all. And Chandi Prasad said that there is no law in that regard.
Got
To that effect, but except on case of extreme hardships. Thereafter comes Rafiq Masih in 2015. Chandi Prasad is of 2009. Right? Then comes Rafiq Masih. Rafiq Masih comes in 2015, wherein it says that it shall not be equitable if you take in the case of this 4. How do you take care of it? Give me a handle, I will take care of. Like in that case, I have taken care. You appeared, Mr. Chakraborty, in that matter?
No.
In that High Court stenographer's matter?
No, Lordship.
Oh, you appeared, no, Mr. H.K. Das? That's Sama Chaudhary's case, Shyamal Chaudhary. You appeared? So there I have taken, although you have not
No,
referred to
Lordship,
Chandi
I think,
Prasad.
Lordship,
that whoever be the DDO, whoever issues the certificate, keeping aside everything, the position of law is that Rafiq Masih is holding the field And thereafter, the later.
And it is not his mistake.
Yes, there is one aspect. Now, the entire issue is with regard to the game is played with regard to undertaking thing. Someone has given undertaking, someone has not given undertaking. Now, latest judgment has come in Judicial Sahu 2025 SCC online, wherein there was an undertaking. Despite that, the Honorable Apex Court has.
That is by Justice Narasimha.
Yes. Despite that, Honorable Apex Court has said nothing doing. You cannot, because undertaking means there are many forms. Nowadays, because central government puts a clause in the pay fixation memo saying that whatever will be there, if there is any mistake, I will refund. That is not an undertaking. An undertaking is that I do hereby give an undertaking that so and so, so and so, so and so.
The undertaking will apply in these cases. Just for example, you want a particular fixation. You say that, okay, you kindly give me this fixation.
Yes.
And in the circumstances, lose the case or anything happens out there,
Correct.
I'm willing to return.
Correct.
That is an undertaking.
Correct.
But
Absolutely.
here is a case of an extreme hardship, which is the case of,
Mistake, hardship. It's a case of mistake.
and more particularly Rafiq Masih,
Yes,
is that those 4 parameters
Yes.
where you cannot.
one really covered.
So,
Lordship, can you look into rule 149 of the Assam Pension Rules? May I read it slowly? Recovery from a gratuity or pension sanctioned under section 2 and 3 of this chapter may be effected in the same circumstances as recovery from an ordinary pension under Rule 21. This applies also in the case of officers who enter service in so and so. So some.
but what stopped you from not taking any action
No,
earlier?
Lordship, we are just watchdog, Lordship, facilitator.
You are the facilitator, then you recover it from those persons who are there. Those people who have done it, take it from them. That is the only way out.
Because
But you have to be more strict.
Lordship.
Taking into account that it is public money, you have to be strict. You cannot be okay for this person out there, we fight it out with, for this person we do not. We take an undertaking. You also know, I also know, this undertaking is being given, otherwise his pension would never get, he would not get his
Because
discharge.
no demand certificate has to be given by the DPO.
Huh?
The no demand certificate.
Then,
Taking note on this, we just acted according to the advice given by the DPO.
so what to do? Allow his petition. Where is Rafiq Masih? Where is the judgment?
With me, my lord.
Hey, judgment to the Judicial Sahu, 2025, SCC online, SC 724. Isn't that?
Yes.
Thousand 25, SCC online, SC 724. Let me do one good thing today. Recovery from employees belonging to class 3 and class 4. He comes under class 3. Recovery from retired employees or employees who are due to retire within 1 year. He comes under that. Recovery from employees where the excess payment has been made for a period in excess of 5 years. He comes under that. Recovery in case where employees have been wrongfully been required to discharge duties of a higher post. In any case where the court arrives at the conclusion that the recovery, if made by the employee, would be iniquitous or harsh or arbitrary to such an extent as would far outweigh the equitable balance of the employer's right to recover. Heard, Mr.
As for my mind.
So and so, the learned counsel appearing on behalf of the petitioner. Mr. T.R. Gogoi appears on behalf of the respondent number 1. Mr. H.K. Das appears on behalf of the respondent number 2. Mr. B. Chakravarti appears for the respondent number 3 and 4. And Mr. A. Solia appears for the respondent number 5. 5. There's no 6. 5. The petitioner herein have approached this court challenging the recovery of an amount of rupees 1,83,583 from the petitioner.
Only one aspect, he has deposited 1,62,000 something, not that. Others 20,000 or something is his gratuity. The exact amount he deposited is lordship 162,648.
He has claimed that
Yes.
183, 583. And submits that the said recovery so sought to be made from the petitioner was contrary to the law laid down by the Supreme Court in the case of State of Punjab versus Rafiq Masih, whitewasher, reported in when? 2000, huh?
4 SCC 64.
2015 4 SCC 334. Wherein parameters were laid down by the Supreme Court that recovery would not be permissible under law. Full stop. For ascertaining the said dispute, this court finds it relevant to take note of the brief facts which led to the filing of the present proceedings. Full stop. On the basis of an order dated 14/11/1991, the petitioner was appointed as a lower division assistant in the scale of pay of rupees 1060-13-1345-ED-40-1635-50-2035-60-2095 with other allowances as admissible under the rules. Subsequent thereto, the petitioner was promoted to the post of upper division assistant on the basis of an order dated 8/4/2004. The petitioner continued to render his service as an upper division assistant till he retired on 31/12/2021. The respondent number 5 had issued a letter on 10/4/2023 informing the respondent number 3 that in pursuance to the letter dated 9/3/2023, the application of the petitioner was forwarded for final withdrawal of the sums to the credit of the petitioner's GPF account, and an amount of rupees 8,39,732 was the amount to which the petitioner was entitled to up to June 2022. In the meantime, there was another communication issued by the respondent number 5 dated 2/12/2022 informing the respondent number 5 issued by the respondent number 4 to the respondent number 5 that the government of Assam in the government of Assam had issued a letter dated 7/11/2022, thereby sanctioning an amount of rupees 7,27,922, being the commuted value of rupees 7,403 out of the pension of rupees 22,210 per month in respect to the petitioner, being the retired upper division assistant and holder of the pension paying order number 919111295296. It was also mentioned that there shall be reduction of pension of rupees 14,807 per month consequent on first commutation. Further it was mentioned that the reduced pension of rupees 14,807 per month consequent on first commutation be paid to the petitioner from the date of receipt of the CVP by the respondent number 3 from the may be paid to the petitioner from the date of receipt of the CVP by the petitioner or 3 months from the issue of the authority. It was mentioned that the pension shall restore after 14 years. Bracket in the case of Assam government pensioners, bracket close, oblique 15 years in case of AIS pensioners and higher judicial pensioners of the Assam government from the date of commencement of the reduced pension. The respondent number 4 also informed the respondent number 5 that to arrange payment of rupees 8,72,655 to the petitioner after recovery of an amount of rupees 1,83,583, which is to be recovered from the arrear and future relief. Taking into account that the petitioner's salary, petitioner's pension, and the other pensionary benefits would be withheld, the petitioner was compelled to deposit an amount of rupees 1,62,648 in the Kamrup Treasury on the ground that there was an overpayment of pay and allowances. It is the specific case of the petitioner that there was no fraud or misrepresentation committed by the petitioner, which had resulted in an overdrawal of rupees 1,83,583, which is sought to be recovered from the petitioner. Being aggrieved by the action on the part of the respondent authorities to recover the amount of rupees 1,83,583 and out of which rupees 1,62,648 the petitioner had to pay under compulsion, the present petition has been filed challenging the recovery which is being sought to be done, that too after the petitioner have retired from his service. It is relevant to take note of that by an order dated 22/1/2024, notice was issued upon the respondents. The respondent number you filed the affidavit.
3 and 4, Lordship, on behalf of 3
The respondent number 3 and 4 have filed an affidavit in opposition, wherein it was mentioned the DTO, that is the respondent number 3, while forwarding the pension papers of the petitioner, had enclosed the Form 19, wherein it was specifically mentioned that there was an overpayment of pay and allowances to the tune of rupees 1,45,358 and also an amount of rupees 17,290 being the leave salary, and there is also overdrawn of gratuity. It was mentioned that the petitioner had already deposited an amount of rupees 1,62,648. It was further mentioned that in addition to the deposits so made by the petitioner being rupees 1,62,648, an amount of rupees 20 lakhs 935,
20,000.
20,935 remained as the excess provisional DCRG, which was required to be recovered. This court finds it relevant to take note of the communication which was issued by the respondent number 3 to the respondent number 4, which is enclosed as annexure R41, wherein it has been mentioned that there was an overpayment of pay and allowances, including leave salary, of rupees 1,45,358 and leave salary of rupees 1,17,290. It was further mentioned that there was an overdrawn of gratuity of rupees 25,935 and the total amount comes to rupees 1,88,583. The said communication, however, do not mention as to during which period there was overpayment of pay and allowances or leave salary or overdrawn of the gratuity. First, this court now finds it relevant to take note of that there is no allegations made by the respondents by filing any affidavit before this court, in spite of due opportunity being granted, that the petitioner, that the overdrawn of pay, leave salary, as well as the gratuity was on account of any fraud or misrepresentation committed by the petitioner. This court further finds it relevant to take note of a recent judgment of the Supreme Court in the case of Jogeshwar Sahu and others versus District Judge Katak and others, reported in 2025 SCC Online SC 724, wherein the Supreme Court, after dealing with the law in respect to recovery of overdrawn amount have held the circumstances in which over recovery was not permissible. Paragraph 8 to 11 of the said judgment being relevant is reproduced hereunder. This court finds it very pertinent to take note of that the Supreme Court in the case of Judicial Sahu, Supra, had duly taken note of the judgment of the Supreme Court in the case of Rafiq Masi, wherein the Supreme Court categorically observed the 5 circumstances when it shall be impermissible for the purpose of making any recovery. Amongst the five situations, the first situation is in respect of recovery from employees belonging to class 3 and class 4 services, bracket, or group C and group D services, semicolon, recovery from retired employees or employees who are due to retire within 1 year of the order of recovery. In the instant case, it is an admitted fact that the recovery was being sought to be made from the petitioner who was a Group C employee. Group C?
My lord.
Group C employee.
Class.
Oblique, Group C oblique class 3 employee. And further, the petitioner have already retired as far back as on 31/3/2000.
12, my lord.
31/12/2021. Under such circumstances, the recovery which have been sought to be made from the petitioner was contrary to the law laid down by the Supreme Court in the case of Rafiq Masi, white versa, Supra, as well as the judgment in the case of Jogeshwar Sahu, Supra. In that view of the matter, this court therefore interferes with the recovery sought to be done in so far as the amount of rupees 1,83,583 from the petitioner on the basis of the communication issued by the respondent number 3 to the respondent number 4, dated enclosed as Annexure R41. Number 2. This court further, taking into account that under compulsion the petitioner had to deposit the amount of rupees 1,62,000. 648. Directs the respondent number 4, 5, 4 and 5 to take appropriate steps.
The administrative department should send a approval to us.
Directs the respondent number 3, 4 and 5 to take appropriate steps so that the said amount of rupees 1,68,648 be refunded to the petitioner.
162,648.
162 of 648 be refunded to the petitioner at the earliest and not later than 30 days from the date a certified copy of this order is served upon the respondent number 3.
He is now the accountant general. Let it come from lordship, from number 1.
3 is that officer.
That has been
This council has made the mistake, na? From respondent number 2. Directing the respondent number 2, 3 and 4. Huh? I just told 3 বুলি আগতে কৈছো to 2 হ'ব. 10,000 cost upon you for making all these mistakes.
My lord, kindly, my
No, upon you.
that, my lord, kindly, my lord, actually, this case was not drafted by me, my lord, I am later.
What?
Come to this court.
You should have been more careful when you draft the petition.
My lord, actually, my lord, this case was not supposed to be moved by me before this honorable court. I accidentally come to, my lord, kindly allow, my lord, that cost may not be imposed, my lord. I have filed my lord, I have filed that IA also, my lord,
For what?
for correction, my lord. Already I have filed an IA that has to be disposed.
I dispute.
Kindly cost may not be imposed, my lord.
এখন ভয় দিবি।
Obliged.
May I please your lordship?
Yes,
I'm so sorry to make a mention here. My lord, today on item number 13 is listed. On the last occasion also, it could not be taken up. And if that matter is not taken up today, I will be thrown out of my jobs. My livelihood is at concern. My lord, so I request your lordship,
we'll take it now.
my lord.
What is it?
Pardon, my lord?
Yes, tell me.
My lord, what happened is that I have filed a review against your lordship's order of 27th of March 2025, by which your lordship was held the view that my appointment as a clerk, peon in the office of the district and session judge is vitiated on two counts. That the guidelines for recruitment was that I was overqualified, and second was that I have concealed that I was overqualified. Now, I have challenged that on one count only, that the qualification which the learned sessions court, district courts are applied, that was with respect to the service rules under the Guwahati High Court service rules, which will be applicable to the staffs and administrative officers of the High Court. It cannot extend to the district court. Why? The issue was that your lordship on the last occasion, my lord has referred me one notification of 4th January 2021.
Yes.
My lord may kindly come to Annexure C. Kindly come to Annexure C.
Page.
The lordship will find page is at
70.
yes, my lord. Your lordship will find that as far as this annexure, this notification is concerned, it reads that in exercise of the powers conferred under Article 229 of the Constitution of India and in suppression of all rules, orders, Honorable the Chief Justice of the High Court has been pleased to amend, notify the qualification of appointment of person in class 4 group D post in the principal seat of the High Court and is outlying benches in the following manner. Quote, a candidate for appointment to the post of grade class 4 Group D in the service of Guwahati High Court and its outlying benches must possess the minimum educational qualification of class 8 standard, and those who have passed SLC or above shall be ineligible to apply for the said post. Candidates possessing special skills may be given preferences on need basis. This shall be inserted as Rule 6D in the Guwahati High Court Service Appointment, Condition of Services and Conduct Rule 1967. So this rule, this notification restricted only to the High Court establishment. Now then there is a second notification came up of 26 April 2021, which I am not much concerned with this particular, but yes, your lordship had rightly pointed out on the last occasion that 4th January 2021, the Honorable High Court has said that it will be this particular, the earlier notification will be applicable to the appointment of staffs in lower courts. Now the question arises is that the notification which the learned Honorable High Court has extended to the district courts cannot be exercised because of the one reason only, because of Article 229. My lord, may kindly see the Constitution of India, Article 229.
What is that?
Article 229 Officers and servants and the expenses of High Court. Appointment of officers and servants of a High Court shall be made by the Chief Justice of the court or such other judge or officer of the court as he may direct, provided the governor of the state may by rule require that in such cases as may be specified in the rule, no person not already attached to the court shall be appointed to any office connected with the court save after consultation with the State Public Service Commission. Clause 2. Subject to the provisions of any law made by the legislature of the state, the condition of service of officers and servants of a High Court shall be such as may be prescribed by rules made by the Chief Justice of the court or by some other judges or officer of the court authorized by the Chief Justice to make rules for the purpose. Provided that these rules made under this clause shall, so far as they relate to salaries, allowances, leave or pensions, require the approval of the governor of the state. 3. The administrative expenses of a High Court, including all salaries, allowances.
Mr. Borgohain,
My lord.
I know 229. Why are you referring to 229?
Now, why I am referring to 229 is that as per the notification which is applicable in the High Court's court staffs, that can be done only by exercising 229. Now the question is that can the power of 229 be extended to subordinate courts?
No.
Answer has to be emphatically no, because your lordship will see in Guru Swami's case of our own High Court, which we went up to the Supreme Court, the Constitution Bench judgment said that the power of 229 with respect to the rule-making power of the High Court Chief Justice is confined only with 229. It cannot extend to the other courts. Now, your lordship will appreciate this, that as far as the recruitment or ministerial staff, that has to be made by a rule. And that rule comes under Article 309. And that is the state.
No. That is not under 309. This is done under 234. 234.
Your lordship will appreciate this, that 234, the district judiciary, that is with respect to kindly recruitment of persons other than the district judges to the judicial service. But the clerks are not judicial service, my lord.
Mr. Counsel, you have to again know that there is another judgment of the Supreme Court wherein it says that the ministerial staff, in view of the interpretation clause given under 236, will come within the ambit of judicial service, and therefore the High Court exercises the powers under 234 and 235 over the ministerial service. That is another judgment in case of Gujjar, R.M. Gujjar. You have to go through those judgments. Don't make submissions.
My lord, your lordship, what I am trying to impress upon your lordship is that.
You see, the power is there under 235 because of the control and the vesting of that control upon the High Court. That power is given to even upon the subordinate judiciary, which includes the ministerial staff.
My lord, yes, your lordship, that will be with respect to superintendents.
No, no, Mr. Counsel. Superintendents is another thing. Superintendents will be coming into the case of under 227. This is not a superintendent, it is a control and vesting. And there is another judgment of the Supreme Court in the case of Nipendra Bakshi. And also another case in the case of this is AIR 1966 Supreme Court 647. This is another Supreme Court judgment wherein it categorically says that it has to be what is control and vesting. It says that it is different from superintendents, which is given under 227. These are all Constitution Bench judgments.
My lord, your lordship will appreciate this, that the recruitment process, can the High Court recruit a ministerial staff of subordinate judiciary?
That is what is done. This is done. That is how it is done in view of the judgment in Renu.
No, your lordship, Renu asks that you make a modality of guidelines. Accordingly, the High Court drafted a rule, but still it is kept in abeyance by this government.
No. I could never drafted the rule.
No, your lordship.
The rule has been made by the state. and with the consultation of the High Court. This is
Exactly.
therefore under 234.
So, but at present, there is no rule as such. So, pending of the rule,
So pending disposal of the rule, the High Court has the power under that control under 235.
but the article does not say the recruitment of ministerial staff, my lord. We have to read the article as such.
Therefore, the Supreme Court categorically observed the judgment was of the state of Madhya Pradesh.
My lord.
The Madhya Pradesh High Court, the question arose to that effect as to whether the power was there over the ministerial staff. That was the second question which was taken by the full bench of the Madhya Pradesh High Court. And that was approved by the Supreme Court in the case of R.M. Gujjar.
So, your lordship, what I am trying to impress upon my lord is that I have a fair case that your lordship can look into this issue because
No, I'm going to dismiss your appeal review now. 2 minutes.
your lordship may pass the order.
Okay. Heard Mr. S. Borgohai, the learned counsel, appearing on behalf of the petitioner. First, Mr. H.K. Das, who appears on behalf of the respondent. Numbers 2 and 3. And Mr. T.R. Gogoi appears on behalf of the respondent number 1. First, the present application has been filed seeking review of the judgment and order dated 27/3/2025 passed in WPC number 1266/2024, whereby this court had interfered with the appointment of the respondent numbers 4 and 5, who are the applicants in the present review proceedings. The interference was done by this court on the ground that both the respondent numbers 4 and 5 were overqualified and respondent numbers 4 and 5, the applicants herein, were overqualified and did not disclose at the time of applying the post pursuant to the advertisement dated 8/7/2021 that they were overqualified and suppressed the vital information before the selection committee. First, Mr. S. Borgohai, appearing on behalf of the review applicants, submitted that there has been an error apparent on the face of the record on the ground that the application, that the notification dated 28/1/2016 only was in reference to the power exercised by the Chief Justice under Article 229 of the Constitution, which is only in respect under 229 of the Constitution, which relates to the employment of the officers and servants of the High Court. First, the learned counsel submitted that this notification dated 28/1/2016 could not have been applied insofar as the petitioners are concerned, applicants are concerned, who are ministerial staff of the subordinate judiciary. Full stop. The said submission in the opinion of this court is incorrect and without knowledge of the fact that by the notification dated, what is that notification dated 4/1/2021?
Yes, my lord.
Where is that notification?
There in the review, 26 April 2021.
No, not
Which
that.
one?
That is for the High Court.
Yes.
I'm not on that. I'm saying about that notification which applies to the subordinate
Yes,
judiciary.
sir. That is annexure D.
That has not been annexed, your lordship, that your
That is
lordship
not
pointed out.
anymore. This is different.
There is one, no, yes,
Dated 4/1/2021.
yes. The
4th January.
by which this has been adopted for.
By which the full court of the Guwahati High Court had adopted the notification dated 28/1/2016, and thereby the Guwahati High Court, in exercise of the powers under Article 235 and 236 of the Constitution, have incorporated the condition as mentioned in the notification dated 28/1/2016, insofar as recruitment to the recruitment of the peons, na?
It says, notified so-and-so and pending, framing of rules, all the processes for recruitment already undertaken in the subordinate courts of Assam, where no appointment has been issued till date, shall stand halted and the first line says, pending framing and approval of the rules governing the eligibility criteria for appointment to post of grade 4 in the subordinate courts within the state of Assam, selection process for appointment to those posts in the subordinate courts of Assam shall be governed by the rules framed and applicable in the case in the principle.
No, you are reading a wrong one. No, not that one. Huh?
By 2016 has been adopted.
Is it said? What does it say?
It says.
No, that is not the one. It categorically says, I've read it. I've passed the 1-2 judgments on that. Not of good help to this court, Mr. H.K. Das.
So sorry.
Absolutely.
Pending framing on or approval of the rules governing the eligibility criteria for appointment to the post of grade 4 in the subordinate courts within the state of Assam. Selection process for appointment to those posts in the subordinate court of Assam shall be governed by the rules framed and applicable in the principal seat of the High Court and its outlying benches notified by notification number so-and-so dated 28/1/2016 and pending for such framing and or approval of rules as aforementioned. All the process for recruitment already undertaken in the subordinate court of Assam, where no appointment order has been issued till date, shall stand halted, cancelled forthwith.
In view of the notification data had incorporated the condition as stipulated in the notification dated 28/1/2016. Under such circumstances, the eligibility, the qualification criteria as stipulated in the notification dated 28/1/2016 was incorporated in the qualification in the recruitment of grade 4 to the post of grade 4 in the subordinate courts within the state of Assam. The notification dated 4/1/2021, reads as under. First, under such circumstances, comma, as the petitioners herein were applicants herein were overqualified, comma, having passed HSSLC, comma, this court had committed no error apparent on the face of the record in passing the judgment dated 27/3/2025 in WPC number 1266/2024. In that view of the matter, the instant review petition being not maintainable, that view of the matter, as the condition, as the requisite for maintainability of the instant review petition is not met, comma, the instant review petition stands dismissed.
Obliged, my lord.
Much obliged.
What is this?
My lord, this is an petition against my lord, the judgment order of the first appellate court. This is the urban area drain control. The landlord filed a suit for eviction against the defense. The trial court, my lord, passed in decree.
You're a landlord.
I'm the landlord.
Hello. You are outside. Yeah, both the appeals petitions, suit and appeal dismissed.
Decree. Appeal is
Why?
so that both the count on the ground of my defaulter as well as bona fide requirement. Now,
Then?
my lord will kindly look into this, my lord, the findings of the my lord trial court.
No, Mr. Ghosh.
Not
Today is a High Court matter day. Okay. This is the matter after vacations. This is the matter of vacations on 12th of August 2025.
My sister.
Yes, what is this?
The petitioner before Lordship, he was a superintendent of Coping section. There was a criminal case against him, and also my lord, on the similar state of facts, my lord, the disciplinary proceeding was there. In the proceeding, my lord, he has been dismissed from service. Subsequently, my lord, he was convicted in the my lord, the criminal case. On appeal, my lord, the conviction has been set aside. Thereafter, the petitioner has approached your lordship, my lord, receiving the order of punishment and the order of my lord, a long time has passed by. He was dismissed from service in 2006. And my lord, the order of acquittal in the appeal is also, my lord, is in 2023. Earlier, he filed a petition challenging that, my lord, earlier the acquittal in the appeal. Primarily appeal in the appeal, my lord, the facts that constituted the basis of the penalty order, that takes my lord, a different my lord, meaning now. If your lordship kindly sees the order of the charge sheet in the disciplinary proceeding and the my lord criminal case, those are my lord identical.
But how, after withdrawal of the without liberty, how can you file this?
Because the course of action for filing this petition is the ground might have the respondents have taken regarding the delay. But the cause of action arose only on my lord 21/11/2023 when the criminal appeal was allowed, and my lord it was filed immediately thereafter.
Hey, AC to give it a correction, both thunder. Now, what are you asking for?
My lord, otherwise he has my lord attained the age of superannuation in 2010. Now he is 75 years old. Perhaps my lord, your lordship may direct reconsideration by the disciplinary authority regarding my lord if he can get his my lord pension. This is already really taken claim.
But did you approach the disciplinary authority after this judgment?
But the
Then, how can I direct? Mandamus? Tell me. Although there is recent Supreme Court judgment which says that if it is on the same facts or the same evidence on record, it may be a case of acquittal and then obviously it will be there. This is by Justice Vishwanathan, na?
yes, my lord. Effect of acquittal in criminal proceeding, my lord, the judgment has discussed in paragraph 20.
Were you dismissed on the ground that you have been, on the ground that you have been, what you call, convicted?
It was independent.
So if it is independently decided, how will this judgment come into the picture? If you were done on the basis of being convicted, or on the basis of that there is a case being filed against you, then obviously the judgment will help you.
I don't expect that the criminal proceeding was pending, and that has been discussed in the matter of inquiry report. That the criminal proceeding is pending, what is the matter stand of the CBI, everything has been discussed.
No, maybe, but was that the basis on which it was done? Because there was no conviction at that point of time. If the conviction is set aside, obviously you get the benefit now. And if it was based upon a conviction, because there is nothing else to decide. The disciplinary authority, in view of, I think that Rule 22. It is Rule 22 now. If a person is convicted,
Yes.
not this one. This will be where? This is rule.
Some service.
Mr. Das,
Yes, my lord.
you and Mr. B. Gogoi.
Yes.
Is the finance.
Yes.
Both of you, after the quotas, come to my office, my chamber.
My lord.
We got there to discuss on that rule.
Draft.
That, yes, the draft rule, because that needs to be sent out there.
Yes.
So there is one problem which I am seeing it out there,
Got
which needs to be taken note of.
I'll inform Mr.
Yes,
Gogoi.
please inform me
Yes, ma'am.
at 4:45
Yes, ma'am.
on the administrative side.
Yes,
This has nothing to do on the judicial side.
obviously.
Rule 10. If you have been done on the basis of Rule 10, then it is a question is different.
Conviction, my lord, in 2012, his dismissal was in 2006.
Then, so it is not on the basis of that evidence you have been dismissed. But the whatever effect it is a allegation is what? Misappropriation.
No, my lord. It was regarding your worship, remember, because that was to everyone, my lord. Just the honor place from the certified copy. The allegation was of forgery. Then, my lord, even the inquiry officer had said that there was no forgery. But then, my lord, penalty was given. And here also, my lord, in the criminal case also, that forgery has
You were functioning as the superintendent of the booking section of Toronto. The duty of superintendent of the included expense of the certified copy. This is not on its criminal element, anything that has been discussed. What is being discussed is your negligence. Now, if it is a case of negligence which have been done, then in that regard, if the negligence you could have said about disproportionate. You may say about disproportionate, but the fact that you have withdrawn without liberty, this idea of disproportionate goes. The problem there will arise with this. Otherwise, it would not. If it was held that you have committed illegality, not only here, the court said that, kindly see here at page 46. of course, from the materials available before this inquiry, it is not possible to ascertain as who has forged the original judgment, more particularly the page number 9 of the original. Hence, it cannot be said that Sri Besburwa had forged the judgment. But as discussed above, it has been sufficiently proved that the certified copy was prepared without following due procedure, and much irregularity and illegality was committed by the concerned officials, including Sri So-and-so, who was the superintendent at that relevant time. From the above, it is well established that Sri Shamalaya acted negligently and committed serious lapse and thus failed to discharge his duties efficiently and diligently. The way the certified copy was prepared, signed, and delivered amounted to failure to maintain devotion to the duty and absolute integrity. The act by the delinquent was unbecoming of a government servant, and it amounted to gross negligence on his part. So, this being so, the main problem is it may be a case of disproportionate, but with the withdrawal you have given up your rights. Problem arises there. We'll have it after vacation. You may think about it. You should have asked that, no? But the main problem is that it was withdrawn. How do I give it? Because you see, that has already attained finality. I would have understood, otherwise the problem arises there. It may be if it is a case of disproportionality, then without liberty it becomes a very difficult proposition for this court. Because it is not now the question of a violation of Article 14. You having waived your right. Think about it, I think. Because giving a direction, I normally don't give consideration direction unless I find that there is a very good legitimate expectation. When do you want it? I'm available on a Thursday.
July 29th.
At the request of the learned senior counsel appearing on behalf of the petitioner. Let me record what I formulated, which may help you out. Heard Mr. M.K. Chaudhary, the learned counsel, senior counsel, assisted by Mr. M.K. Sharma. M. Sharma? And Mr. H.K. Das, the learned counsel, appearing on behalf of the Guwahati High Court. The present petition has been filed. The petitioner herein was discharged.
Superintendent copying section.
Huh?
Superintendent copying section.
Now, what was your punishment?
Punishment was, my lord, dismissal order case 64.
The petitioner herein was dismissed from service by an order dated 13/3/2006 on the basis of the inquiry report, upon consideration of the inquiry report submitted by the inquiry officer in disciplinary proceedings number 5/2001. It is relevant to take note of that the inquiry officer, while arriving at its finding, observed that from the materials on record, it was not possible to ascertain as to whether the petitioner had forged the judgment, and more particularly page 9 of the said judgment. But on account of but on account of the petitioner having acted negligently and committed serious lapse by failing to on his failure to discharge his duty efficiently and diligently, it was observed that the act done by the petitioner was unbecoming of the government servant, and it amounted to gross negligence to duty and misconduct. Full stop. It is relevant to take note of that pursuant to the said inquiry report being submitted and the petitioner being afforded an opportunity, the order of dismissal of service was passed on 13/3/2006. An appeal oblique review was filed by the petitioner, which was also dismissed. The petitioner thereupon filed a writ petition, which was registered and numbered as WPC number 1982/2007, challenging the inquiry report as well as the penalty so imposed upon the petitioner. However, the said writ petition was withdrawn by the petitioner on 10/12/2013 without seeking any liberty. It further appears that the petitioner was initially convicted in a proceedings initiated under section 120B, 468, 471 of the Indian Penal Code, read with section 13(2) and 13(1)D of the Prevention of Corruption Act 1988. The said conviction was overturned in Criminal Appeal number 97/2012 by this court by the judgment and order dated 21/11/2023, and it is under such circumstances the present proceedings have been initiated. Though the learned the senior counsel appearing on behalf of the petitioner submitted that as the petitioner have been acquitted, the petitioner, the dismissal, the penalty of dismissal from service as imposed by the order dated 13/3/2006 is required to be interfered with. This court, having perused the materials on record, find it relevant to observe that the inquiry officer did not hold the petitioner had forged the document. Rather, on the ground that the petitioner was negligent and his action was unbecoming of the government servant, of a government servant, of a government servant, comma, and the said enquiry report being accepted, the petitioner was dismissed from service. Full stop. It is also relevant to take note of that the dismissal of the petitioner, and that neither the enquiry report nor the dismissal of the petitioner was on the basis of any conviction against the petitioner at that relevant point of time. Full stop. The question therefore arises that the petitioner, having withdrawn the writ petition, and the dismissal was not on account of the allegation of forgery, which was the subject matter of forgery, or gratification, which was the subject matter of the criminal proceedings, illegal gratifications.
Conspiracy. So,
Forgery, criminal illegal gratification has to be there, and illegal gratification, comma. The question therefore arises as to whether the withdrawal of the writ petition being WPC number 1982/2007, comma, would bar the instant proceedings. Full stop. Mr. M.K. Chaudhary, the learned senior counsel, submitted that he would request some time to look into the said aspect. Accordingly, list the matter on 31st July.
matter, the lordships wanted me to file the affidavit. Lordship will remember that educational qualification was taken up as a criteria to ascertain the minimum merit.
Minimum?
Minimum merit.
Oh,
there
yes.
were components, my lord, 4 components. One of the components was, my lord, educational qualification. Lord, may I pray that this matter will be taken up after the vacation? I'll clarify this position, my lord. Actually, as well as legally by filing.
You have not filed affidavit
No, my lord.
after 1 month also.
Yes, true, my lord.
It seems that the High Court is sleeping.
No, no. Actually, my lord, in fact, I tried to convince myself with regard to the position of law also, my lord. I was going through, my lord.
Cost?
Cost, my lord.
15,000?
Cost, my lord.
High Court is very rich.
My lord, it's not about the High Court, my lord.
Yes, it is the High Court who have not joined it.
I took
It's
time.
a matter of 2024.
Lord, cost may not be imposed, my lord. I took time to go through the
Okay,
everything.
cost
I'll
upon you.
assist you.
Upon you. That day I imposed a cost upon our counsel for filing the writ petition wrongly as a deterrent. So the cost is now upon you as a deterrent. Don't penalize the High Court. Penalize your pocket.
Chance your lordship will give me perhaps.
I gave you the last time only last chance.
Actually, my lord, the selection committee minutes that I could produce on the last occasion before your lordship. It was not there initially with me. Then after perusal of the selection committee minutes, my lord, your lordship direct me, you file an affidavit. But in the meantime, I contacted with the selecting authority also. And myself also, my lord, I have done some work to ascertain the correct position of law. I have found something, my lord. I just want to bring that thing.
Because my specific question is why different marks have been given in by different persons.
First, by the component in the 4 parameters fixed by the selection committee. That was your lordship's first query.
No.
Then second query, when it's come,
it was seniority come merit, madam.
Ah,
That was, and second.
during the
query-
year, H.K. Das appearing on behalf of the has placed before this court the records as to how the selection was carried. From the said records, it is seen that although the minimum marks, qualifying marks was fixed at rupees at 30, but the petitioner herein has missed out the said minimum qualifying marks by a fraction of a mark, that is 0.67, as the petitioner had got 29.33. The learned counsel for the petitioner further submitted that the criterion number serial number 4, being higher educational qualification carries weightage in marks, can only be objectively adjudged and cannot be subjectively adjudged. Referring to the marks which have been given by the 3 members of the selection board, the learned counsel for the petitioner appearing on behalf submitted that in respect to the criterion number 4, one member has given mark 6, the second member has given 7, and the third member has given 8. He further submitted that even in the minutes of the board's meeting held on, there is no whisper as to how the marks in respect to the criterion number 4 is to be determined. The learned counsel for the year further submitted that even after perusal of the matter would show that there is no mention that the average of the marks given by year would be taken into consideration on the basis of that.
Correct.
I'm not correct, it is an order.
I'm sorry, my lord. That's what I wanted to convey, my lord. It's there in the order. So that was the 2 queries, my lord. So I just clarify those 2 queries, my lord, before the lord. So that's much,
Chala, last chance.
my lord. I'm highly obliged.
Otherwise, cost will be imposed.
While
But
let
this
me
time 10,000, next time 10,000, make it 20,000 next time cost.
do that for vacation, lord, I'll try to file it. So that immediately after. the
Mr.
vacation-
H.K. Das, the learned counsel appearing on behalf of the Guwahati High Court, submits that he has already prepared the affidavit and the same has been sent for vetting and would be filed immediately after the vacations. List the matter on 31st of July 2025. In the meantime, the affidavit be filed by 28th of July 2025. It is observed that if no affidavit is filed, this court would be constrained to impose costs. Further, the records of the selection proceedings be also produced before this court on the next date.
Much obliged.
And to withdraw,
Oh, withdraw?
the matter is first search, my lord.
Mr.
Yes, I can, my lord.
You have filed the wakalatama?
Yes, ma'am, my name is Jim.
Mr. So-and-so appearing on behalf of the petitioner submits that he has instructions to withdraw the instant petition. Accordingly, Mr. H.K. Das appears on behalf of the respondent and taking into account the above, the instant petition stands closed on withdrawal. Interim order, there is no interim order.
They can, respondents can proceed with the selection. The respondent.
The
can proceed
respondents
with
shall proceed with the selection proceedings if not yet completed.
the- Highly.
Yes, where is Mr. R. Mojumdar? Why no affidavit has been filed?
We file our affidavit.
Is it?
Reply, the reply is also.
What is your stand?
My lord, kindly come to annexure 7 of the writ petition, my lord.
Yes.
My lord, here what happened, my lord? LDS copies.
No. That everything understood. The law is very clear. No. Why did that MACT person issue the appointment letter to the respondent, private respondent prior to the petitioner? Although the petitioner was higher in the select list. Why? That's the question.
If we have stated in our affidavit that the private respondent appeared before the authority.
How?
on-
How did he appear unless this particular officer had something to do with that private respondent by calling him over the phone. Tell me, how is it possible when the petitioner was higher in rank in the serial case? There was a direction issued by the High Court to appoint them and mentioning the seriality. Kindly see that High Court's order, if I remember, because when I admitted this, I was very particular on that. Where is that? Yes,
At page 35.
page 44. 44.
44.
As directed, I am to inform you that the following candidates have been provisionally selected for appointment in your establishment. You are requested to issue the appointment letter to the concerned candidates of Yemen and also issue appointment and initiate the police verification and so and so. Thereupon, you issue the appointment letter to the petitioner on 3/5/2019, isn't it?
My lord.
And the petitioner immediately on that very day he joins.
Join.
Whereas, in respect to
Respondent number.
the respondent number, where is that person? You have appointed, you have issued it one day before.
On 31.
No, one day before you did it. Where is the document? Send it somewhere.
My lord, on 34, it is my annexure A. On 304. And the appointment letter of petitioner was issued on 3/5.
3/5. Why? Why the petitioner, this person was given and therefore she joined one day before?
One day before.
Well,
She joined on 2/5.
obviously she knew it earlier.
But the rule is there. According to the rule.
Rule is there. So I will accordingly say that this appointment letter will be deemed to have been issued on 34 and thereby say that as he has joined within 15 days, he will be considered a senior. Huh? Appearing on behalf of the petitioner, Mr. G. Bush. What about the other respondent? You have served it?
Then he appeared, madam.
Who?
Mr. Pegu.
Who is Pegu?
Green Pegu.
Girin Pegu. Where is he?
Today he is not able.
Chalo, none appears. Should not, heard Miss So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. G. Bush, the learned counsel who appears on behalf of the respondent numbers 2, 3, 4. Right. Mr. T.R. Gogoi appears for the respondent number 1. Full stop. None appears on behalf of the respondent number 5 when the matter is called up. Full stop. The petitioner herein is aggrieved by the action on the part of the respondent authorities in putting the petitioner below the respondent number 6 in the gradation list of the staff for the year 2024 of the Office of the Motor Accidents Claims Tribunal, Nagaon. On the ground that the same that the senior, on the ground that the petitioner having secure, having, being, on the ground that the petitioner being higher in the merit list ought to have been above the respondent number 6 in the gradation list. Full stop. For the purpose of deciding the said dispute, this court finds it relevant to take note of the facts which led to the filing of the present proceedings. Full stop. On 13/11/2018, the but you are not challenging as regards Nobojiti Bora, na?
They would come in as a, he has also been placed above me. Lipika and that has also been forwarded to become for the next promotional post. So in representative capacity, if Lipika goes under me, the rest have to go.
Why?
Just wonder, all the three were below me in the merit list. My challenge is that it should be according to the merit list.
Okay.
The appointment has to be for the merit list.
You have not made him a party, Nobojiti Bora.
No, madam.
Then?
For the merit list.
No, I cannot touch him without you making him a party. We should dismiss your petition on the ground of non-joinder of necessary party. I am a civil
At
court.
least for- Lordship will allow me to
Necessary
identify-
party. My goodness.
I noticed it yesterday. I had a discussion with her that why that man is not a party is what I told her.
Then,
And she will give me one week's time. I'll just impede him as a party, amend them. Otherwise, my thought was that if the merit list is.
no, your thinking would not help you. Mr. R. Mojumdar, Mr. R. Mojumdar Council submits that there has been an inadvertent error in not making Mr. Nobojiti Bora a party to the instant proceedings. In as much as if any direction is passed, full stop. This court also is of the opinion that the directions which the petitioner seeks in the instant proceedings cannot be granted without Sri Nobojiti Bora being arrayed as a party to the present proceedings. Full stop. Accordingly, list the matter upon filing of appropriate application by the petitioner.
Public.
If I saw it on that day, I would not have even issued notice.
Apologies. Obliged.
Who is appearing? TJ Mohanto. Not there. Affidavit not filed. Recovery proceedings as well as non-consideration of the representation submitted. Okay, let me come back. In a matter out here in Guwahati, High Court matter, name has not been shown. So it is seen that the none appears on behalf of the petitioner on call. Full stop. The name of the Standing Counsel of the Guwahati High Court have also not been reflected. Full stop. taking into account the above, list this matter on 14th of August 2025. In the meantime, this court directs the Guwahati High Court as well as the Finance Department, who is that? Well, as the state respondents to file their affidavit on or before the next date. Not file affidavit.
This has come to me. I'll have to file my, initially, it was with Mr. Nair, the Honorable Mr. Nair. In fact, there was a notification issued by the registered administration that your lordship will find page 43. Grade 4 employees to be uniformly considered for the post of process server. This selection was for the post of head process server. He was agreed that the other grade 4 employees were also brought into the zone of consideration, but this notification was not challenged.
What is the challenge here?
Challenge is the promotion of the private respondent to the post of head jari karab.
On the ground?
On the ground that the other grade 4 employees, they should not have been brought into the zone of consideration, which was done by virtue of that particular notification.
And what is the eligibility?
Advertisement says, page 29.
He is working under the year of the district in sessions of Dimahasau. Okay. A petitioner's counsel is not represented.
Yes.
The petitioner counsel is not represented, nor the affidavit of justice service have been filed. Considering the above, for the ends of justice, the matter stands adjourned to be listed again on 24th of July 2025, It is observed that on the next date, if the petitioner is not represented, it shall be deemed that the petitioner have lost interest in the instant proceedings. An appropriate order will be passed.
Highly.
Yes.
The selection and appointment of the respondent number 5 is under challenge.
Huh?
Last occasion, your lordship directed the council for the Guwahati Court to file a status report.
Respondent number 5, who is appearing? Yes, what is it? You have filed your affidavit?
No, Lordship, I was appointed yesterday.
Why?
I received the copy from legal aid yesterday.
Legal aid. Chalo. What is your stand now?
Lordship, according to lordship, the selection, the criteria of selection was changed after the publication of the written test.
After the
Publication of the written test, lordship.
why?
On 14/8/2023, the advertisement was issued by the CJN Golaghat for two numbers of posts. One was reserved for the scheduled caste category and one was reserved for the scheduled tribe hills category. Your lordship will find the advertisement at page 21.
Then,
And in the advertisement at page 22, the selection process consisted of two stages. Stage 1, common written test of 50 marks, and stage 2, interview viva voce of 20 marks. The petitioner being an SC Hills category of Kuki tribe, he applied, and written test was held on 25/2/2024.
then,
Then lordship,
what is the name of the petitioner?
Kamkholun Lozen,
Where is he in that select list? What is SC? ST?
lordship, SC Hills,
Long jam is where? Here, 38.
lordship,
Roll number 38. You got 32.
lordship.
And how much did the private respondent get?
That your lordship will find at page 30. Only 12 marks was scored by the private respondent. Page
Then?
30, serial number 17, lordship.
Then, Viva Voce.
Then viva voce was conducted.
Viva
Wherein the
Voce,
petitioner
you got how much? Where are you?
Serial number 8, lordship.
Serial number 8.
8.
Huh?
51.
Where?
Serial number 8, page number 33, lordship.
See. You have got 51.
Lordship. And
And the
the private
respondent have
respondent,
got
lordship will find that serial number
56.
22. 56.
Viva Voce is only for
20 marks.
20 marks.
20 marks.
Then how did he get so much?
And in fact,
So they had 20 marks for each.
for each, for 3 members.
And the advertisement was to that effect?
No, lordship. Advertisement is absolutely silent to the effect, only 20
Yes,
marks.
government. What do you have to say?
Marks in the viva voce would be given to the candidates, and the written exam would be screening. That's what the.
No. Your advertisement says the selection process is 50 marks for written and 20 marks for viva voce.
Yes.
Now, if 50 marks is for written, then the petitioner have got some 45 marks, 35 marks,
30.
30 marks.
30.
And
And the private respondent has scored 12 marks.
12 marks.
Marks, which was given in the written test, was not in fact added in the total.
The academic was the screening, was the screen out,
Which one?
written test.
They say, lordship, your lordship.
No. But there are only, it is very clear from the advertisement. And what is this? These judges, they don't understand. One person has got 39. And because of the viva voce test, we have given him 56. So he is appointed.
Okay.
You cannot better you with your affidavit. We interfere.
And the result was declared on 23/4/2024, and the resolution was passed on 25/4/2024. After 2 days of the publication of the result, they took a decision that only the marks that your lordship will find at page number 39 of the affidavit filed by the respondent number 3 and 4. Affidavit in opposition of the respondent number 3 and 4. Page number 39. Yes, okay. Para number 5. 4, that in light of the circumstances of obtaining a reported on
The
25/4/2024.
resolution that the marks in here will be given to as per advertisement. Moreover, it was resolved that the said that as per resolution of Iman, interview will be comprised of 20 marks for each candidate per interviewer. Where does he get this?
Still, lordship, the advertisement no way says that the marks of the written test will not be counted. Secondly,
Are these judges not aware of what is law? And with all impunity file affidavit? And tomorrow, if anything happens out there, how will these judges do? My goodness, this happens to be my district also.
In fact, they say that the marks in the written test are qualifying in nature. That
Ah,
marks in the written test are qualifying.
how can they say when the advertisement say this?
Yes. In fact, that is not qualifying in nature because of the fact that a person has scored only 7.5. He was also called for interview, but he remained absent.
Madam, we interfere.
Sometimes.
Respond. Respond. There's nothing there to respond.
Lordship,
What is there to respond? We immediately stop your payment of any payment. This can't happen like this. There is no stay.
No such thing.
Yes.
the order says that it will be subject to the outcome of the.
Outcome, this is the outcome also does not arise here. Absolute illegality. This was a case of any state government thing. We would have said that kindly take the salary from this officer. The salary which have been paid to you, we won't say anything, but that amount should be recovered from the officer, the CGM, who have done this. Chalo. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Ms. S. Sharma appears on behalf of the Guwahati High Court. Mr. T.R. Gogoi appears on behalf of the respondent number 2. Ms. S. Sharma appears on behalf of the respondent number 1, 3, and 4. Ms. B. Chaudhary appears on behalf of the respondent number 5. The petitioner have challenged the appointment of the respondent number 5 the selection of the respondent number 5 by the order of the by the select list published on 1/7/2024 and the subsequent appointment of the respondent number 5 to the post of office peon in the office of the Chief Judicial Magistrate Golaghat. The facts involved in the instant proceedings is that on 14/8/2023, the office of the Chief Judicial Magistrate Golaghat had issued an advertisement calling from eligible candidates for filling up of 2 posts of office peon. One post was reserved for scheduled caste category and the other post was reserved for scheduled tribe hills category. In the said advertisement, the selection process was duly mentioned. The said selection process as mentioned in the said advertisement is reproduced here in below, page 22. Selection process the map on the diagram. From the above quoted selection process, it is seen that stage 1 pertains to a common written test of 50 marks and the stage 2 pertains to an interview oblique viva voce of 20 marks. Pursuant thereto, the selection was conducted. It is relevant to take note of that the present proceedings only pertain to the selection so made in respect to the office post of the office peon reserved for scheduled tribe bracket hills category and not in respect to the scheduled caste category. Full stop. In the written test which was held on 25/2/2024, it is seen that the petitioner herein obtained 32 marks out of 50, whereas the respondent number 5 only obtained 12 marks out of 50. Full stop. Surprisingly, in the viva voce interview, which was held on 30/6/2024, it was held of 60 marks, thereby giving 20 marks against each interviewer. Full stop. The petitioner was allotted 51 marks out of 60, whereas the respondent number 5 was allotted 56 marks. Full stop. Solely on the basis of this viva voce examination, viva voce oblique interview, the respondent number 5 was selected by the select list dated 1/7/2024 impugned in the instant proceedings, and the petitioner herein was put in the waiting list. First, the petitioner is aggrieved that the respondent authorities have changed the rules of the game after the advertisement, in as much as the total marks of 20, which was in as much as when the interview oblique viva voce test had only 20 marks, comma, the selection, the selection committee on their own after conducting the interview test, isn't it? After the interview, have made this 20 marks, made it 60 marks, thereby 20 marks each for each interview.
After the written test.
After the
publication of the written test.
After the publication of the interview written test, changed the rules of the game by earmarking 60 marks for viva voce, thereby 20 marks against each interviewer. And solely on the basis of this interview, had selected the respondent number 5 to the post of office peon. Full stop. Ms. S. Sharma, the learned counsel appearing on behalf of the Guwahati High Court, submitted that the written test was only a screening test, which was, and thereupon, on the basis of the viva voce examination, the candidates were selected. Full stop. Ms. B. Chaudhary, appearing on behalf of the respondent number 5, supported the stand of the Guwahati High Court as stated in the affidavit in opposition. Full stop. This court have duly perused the materials on record and have heard the learned counsels appearing on behalf of the parties. Full stop. It shocks and surprises this court in the manner in which the selection committee changed the rules of the game after the written test, as is an admitted stand in the affidavit in the opposition filed by the respondent number.
3 and 4.
No, that person who filed it. Respondent number 4. The advertisement clearly stipulated the selection process to be of 50 marks in the written test and 20 marks for the interview. Full stop. It is seen that in the written test, the petitioner herein received or obtained 32 marks out of 50. Whereas the respondent number 5 only obtained 12 marks. Full stop. The stand so taken by the respondents in the affidavit that the written test was a screening test, in the opinion of this court, belies the contents of the advertisement which have been issued, and it seems to be an afterthought in order to accommodate the respondent number 5. Full stop. Further to that, it is seen that it was never, further to that, it is seen that the respondent number 5 have been selected on the basis of, solely on the basis of the interview, which is also not permissible as per the well-settled principles of law. Full stop. Considering the above, it is therefore the opinion of this court that the respondent authorities, more particularly the respondent number 2, 3, and 4, have violated the mandate of Article 14 and Article 16 of the Constitution in selectively, in selecting the respondent number 5 to the post of the office peon. Full stop. Under such circumstances, this court interferes with the select list dated 1/7/2024 insofar as the post of the office peon in the category, in the STH category. Full stop. The appointment of the respondent number 5 is also set aside and quashed. Full stop. This court, however, observes that the respondent authorities shall not recover any dues from the petition, from the respondent number 5, any amount during the period when the respondent number 5 had rendered his service, in view of setting aside his appointment order. First, the respondent authorities are directed to proceed with a fresh selection to the post of office peon, STH, in the category of STH by following the due mandate of law. Same, Mr. Sharma. I'm the portfolio judge.
The event of a fresh selection process, if there is any difficulty with regard to the age of the petitioner lordship. Your lordship may kindly make an observation with regard to that also.
What?
If there is he is already 37 years of age. Now if
You don't have any problem.
43 years is the upper limit. Yes.
You know that.
Yes. Obliged.
Yes, what is this?
The service on response number 7 is complete as per the report.
Complete. Affidavit file 5 and 6.
6, my lord, 2 and 3 has gone for vetting, my lord.
What happened? Who has been appointed?
Number 7 has been appointed. They took the plea that for promotion to the post of process server, I need to be an HSLC pass. That was not the condition in the rules.
Hmm?
They say that to become a process server, to get the promotion to the rank of post of process server, I need to be HSLC pass.
You have to be?
HSLC pass, class 10
Ah.
pass. But for the rules which were then applicable, it was not HSLC pass. An affidavit is filed by the learned CJM saying that this is the rule we refer to, and there it is quoted as HSLC pass is a requirement. I have brought on in my affidavit in reply, I have brought on record an affidavit filed by the Guwahati High Court Registry, which says that it is not the requirement. HSLC pass is not the requirement.
What is the requirement?
But a certain tenure in the lower post as a peer is the only requirement for promotion. For direct recruitment, yes, HSLC is the requirement, but for promotion, it is only to be 5 years of tenure and on the lower post. So now, which of the two rules should have been referred? If it is the rule that I have referred to and which has been referred to by the registrar in his affidavit, then my lord, the requirement of HSLC was not there.
We have 4 councils from Guwahati High Court. Every 4 council has different rules. Every person will come. We have also the experience of one council arguing, then the other council jumping out there saying that that council is not right. So don't go by the affidavit of the High Court.
Otherwise,
Let them file the affidavit.
yes.
Ms. S. Sharma submits that the affidavit to be filed by the respondent number 2 and 3 has gone for vetting. She submits that it will be filed within 2 weeks from today. List this matter on 31st of July 2025. In the affidavit on behalf of the respondent number 2 and 3 be filed on or before 28/7/2025. Taking into account that the matter pertains to the year 2024, it is observed that if no affidavit has been filed, affidavit is filed on the next date, this court would consider imposing costs. Yes, what is this, madam? What is it challenging? Disciplinary proceedings.
My lord.
Urgency?
Before
I've got
proceeding-
lots of orders to sign.
before
What is this?
Reduction of scale of pay, my lord. A reduction of pay.
That is a punishment.
punishment. Before the lordship proceeding to the effect,
Huh?
For proceeding lordship, make sure that another proceeding of impose against the petitioner in the petition directed for compulsory retirement on 25.
Subsequent DP, he's saying in a subsequent DP, the petition has been imposed with a penalty of compulsory retirement in 2025.
And what do you want to do?
Back to that appeal is pending, to that appeal is pending. Your lordship, I just pray that matter may be taken up because if that goes,
But if you are compulsorily retired, why they have gone for the second disciplinary? So how does it have any relevance there?
appeal. Was with regard to this issue also, with regard to this issue and the other everything was examined in that. One of the reasons for citing the compulsory retirement was with regard to this earlier DP, present petition.
So if we set aside this, it will help you.
So, the compulsory
No, that might be a different ground then, because most probably the compulsory retirement must have been given on the ground that you are a habitual.
yes.
Habitual. That is the reason why. Now, if we hold that you are not habitual, then it would help you in the other DP. Isn't it? So then I think you should have urgency in the matter. Because the basis on which the decision taken that you should go on compulsory retirement is on the basis of this DP also,
My lord,
where there is an imposition of penalty
my lord.
without taking into consideration that there is a pendency of a proceedings. You ready? Why you have been imposed?
My lordship, what happened was that one person, when petitioner was posted as miscase assistant and execution assistant before the Honorable Court of Munsif Kasar at Silsar, one person has filed a decree of ejectment. A plaintiff has filed decree of ejectment against 11 defendants. Those defendants did not appear and SR is proceeded ex parte against them. Thereafter, my lordship, the judgment after they have filed for execution of the decree, 2 writs were issued. In between, one of the defendants they approached Honorable High Court, in which a CRP was filed. In that CRP, my lordship, stay was there. So, as the stay was there, the execution process was at hold. When the matter got dismissed at High Court, the CRP got dismissed at High Court, the plaintiff has filed a petition before the executing court that since the stay vacated and the CRP is dismissed, it may be proceeded. On that ground, initially 2 writs were earlier issued, but stay was there as such the court directed for execution of the decree. During the pendency of the execution, one of the defendants has filed a petition before the court for stay of the execution process. In that petition, they have not mentioned the case number of the original decree, neither the execution case. And as such, the Honorable Court has stayed the process of the execution. But during the process, the counsel of the defendant has neither obtained the certified copy, neither has mentioned the details in the execution case, neither the executing court has called for the records, or neither the executing court has even mentioned the original execution case. As such, the writ got executed. And after the execution of the writ, the defendant came before the Honorable Court with a petition that there was illegality and injustice done upon him since the execution was already stayed, but during the process it was executed. So a report was called for the Nazir as well as the petitioner who was the miscase.
You are what? You are the Nazir. Huh?
I was the miscase assistant and execution assistant at that time.
Execution assistant then?
Miscase assistant
Okay.
at that point of time.
So your thing is that that order by which this court stayed it was not brought to your information.
Not my information, neither the honorable court, both were kept in different almirahs, different petitions, different covers. The honorable court has also not mentioned with regard to that execution case in its order. And as such, it got executed during the process.
Now tell me what is the finding of the inquiry officer?
My- Was that the thing is, the following statement of allegations were minority find was that while you are working as mistress assistant and execution assistant, Munsif number 1 Silver in the year 2011, you in collision with decree order title sheet number test appraised the stay order dated 21/7/2011 passed by the then landed Munsif number 1 Silver saying the execution of the decree in title suit number test, and you by willingly ignoring the state stay order prepared the writ for delivery of possession in execution case number 8, made the state writ of delivery of possession ready and issued which was executed evicting the judgment debtor Sopon Kumar Dev from the decretal room. And as such, my lord, the findings at page 109.
Kindly come to 111. Last paragraph.
My lord. But from the evidence of the state delinquent employee himself, it appears the writ in title execution 6 of 10 has been prepared by him on 5/8/11, following last order passed on 3/8/11 in title execution 6 of 10. After 2-3 days from 5/8/11, but before 10/8/11, he has gone through the case record of miscase 36 of 11 and found that there was a stay order, but there is no mention of any title execution case number in the state stay order. After going through the stay order passed in miscase 36 of 11, he did not approach the learned Munsif number 1 for clarification as to which title execution case has been stayed by the state order passed in miscase number 36 of 11.
When was the stay granted by the High Court? Where is the stay order granted by the High Court? Page?
That is, my lord,
Where?
my lord,
What happened against that? Mister, what happened against that judge? What action have you taken against the judge, the High Court? Who issued the writ? You are taking action against him, on the ground that he did not inform the Munsif about the stay order.
Yes.
Didn't? What action have you taken against the judge who was also responsible when that order was there? It It is under his agents. The order of execution was passed.
Yes.
He is in control of the execution proceedings.
Yes, ma'am.
Did you take any action
If
against
you
him?
also kindly come to page 1112. Third paragraph. It was not made known to the judge.
How? Why?
If you
The
look,
order has been passed by the High Court.
yes,
That is what I am concerned. When we pass an order, it is the responsibility of the councils who represent to apprise the court, not to the office assistant.
yes. But here he saw. The paragraph on, in page 1111, what triple one, Rosif has asked her to read. It provides, but from the evidence of the same delinquent of employee himself, it appears that the writ in title execution number 0610 has been prepared by him on 5811, following last order passed on 3811 in so and so, after 2-3 days from 5811, but before 10-8-11, he has gone through the case record of miss case number so and found that there was a stay order, but there is no mention of any title execution case number in the said stay order.
That is why I'm saying.
Yes, there was a stay order, he saw it.
How did he know that it is in respect to that case?
Thereafter, my lord, after going through the stay order passed in so, he did not approach the learned Munshi.
This is an allegation.
Yes,
He did not inform. So where is that order?
Page 35. Coach. Right? 10 to 2011.
Where?
Page 35, 10 to 2011 also.
This was passed by him.
But-
Posted the case on Iman for motion hearing the. This is an order passed by him. I'm not on that. Where is the
But,
High Court's
yes,
order?
yes,
Where is the High Court's order?
there is
Ah,
a-
that- It is the High Court's order which have led to the problem. Where is the High Court's order? No,
It is 48 yes, court in High Court order
madam,
is not there.
you are not understanding. You are not helping your own case. You have to produce the CRP order. The petitioner Anupal submitted. Won't he?
Page
No,
48.
not this one. The petitioner Anupal submitted that he had filed revision and the Honorable High Court passed an order on 11 to the year for motion hearing. The petitioner along with so-and-so also filed a letter of engagement adducing so-and-so and prayed for remand. This is not the order. In the light of the High Court's order, the execution of this is state. I'm not on that. We are concerned with 3-8.
3811, 48.
Entire case you have made the wrongly. No, this is 3-8. Thereafter, what happened?
After 3
Where is the order passed by the High Court in this case? Seer will be as seer of the Imam. Seer put up this in petition filed by the judgment debtor for recalling the writ issued on, this was on 10-8. When was the execution done?
execution was done on 12 execution was done on 11/8/2011.
11-8. For recalling the writ as an order dated was passed in so-and-so will be as seer of so-and-so. Call for the report from the Nazir so-and-so for report and objection for a. When did the High Court pass the order?
With regard to the dismissal of the CRP,
No. Where is the stay?
stay was by the executing court only. The executing court only has given the stay. The judgment, one of the defendants has filed before the executing court only. The executing court has only granted the stay,
Where is that order?
my lord. Page 7.
Huh?
Page 78.
Here put up to the scene petition filed by the man under order 22 read with so and so. As per district judge, let record be put up before the year. Where is it? Say,
Page 78, my lordship, 21/7/2011. Perusia Hart Learning Advocate for the petitioner issue notice to the office. The execution of ex parte decree title suit number death shall remain state until disposal of this petition.
this is given by the Munsif.
My lordship, they have filed
Now,
a
this
petition
is the
before
executing court.
my lordship.
And why the executing court did not know? He had stayed it, and thereupon what has happened? Again, he vacated it on 13/8. 3/8, he has vacated it.
While filing the petition for the stay of the execution, the
No, madam. What is this miscase 36? Miscase number 36/2011 is where?
case number 36/2000.
Where is that? This miscase is filed where?
Page 75, NXI page 75.
It is filed where?
It is filed before the court of Munsif only, my lordship.
So isn't this the same executing
Yes.
court?
Sure.
Then why did that court on 3/8/2011 vacate it and issue the writ? Mr. H.K. Das, why did this happen? Isn't it the responsibility of that court?
Page 109 findings, my lord.
Forget about 909. Kindly come to page 48.
48. Yes,
Okay.
yes, ma'am.
Now kindly see 3/8/2011.
Yes.
Decree holder is represented. Decree holder has submitted a copy of the order dated so and so passed by the Honorable High Court in Civil Revision Iman by which the revision petition has been dismissed and the earlier interim order of so and so has been vacated. Since so and so filed by the decree holder for issuance of writ with the help of the Nazir. Now, and so heard so and so being said, I allow the petition, reissue the writ. Now, this very judge had stayed in Mizze case number 36. Isn't it his responsibility first?
What it is referring to?
Page 78. This seems to have been a petition under Order 9 Rule 13. So in that suit, where it is the same judge, in the Order 9 Rule 13, he states the execution of year shall remain until disposal of so and so. And the same judge, in the writ, in the executing court, executes the writ. That's the case. What is the fault of this person concerned? Small fries. I would have understood if he is the different executing court. It's the same executing court. Then, and when the execution proceeding is going on, he should have been more careful. He knows the same executing, and the lawyer should have informed him. And on one hand, in spite of this order, he issues a writ. That's the ground. My goodness. See, I told you. The compulsory retirement will also be on the.
If my lord kindly considers this finding at 112.
Forget about 105. We are concerned with this. What has happened is, seems, there is an ex parte decree. Now, in the ex parte decree, they file an Order 9 Rule 13. Okay, which is registered as Mizze case number 36 of 2011. Now, this case is filed in the suit. Okay. Now, in the meantime, there is a proceeding which was filed before against the judgment against an application filed under Order 21 Rule 26, which was which was rejected, and the matter went to this court, came to this court. This court dismissed the petition, and therefore the lawyer concerned appears on 10/8/2011 and produces that, look here, the High Court had dismissed the revision application being 47, and as such issued a writ. Now, this very court does not take into consideration that he had passed an order under Order 9 Rule 13 in the proceedings under Order 9 Rule 13 staying the execution. Okay? And this has led to the execution. Now, what is wrong with this official? It's the fault of the court. No. Why? Because on one hand, the court passes an order for issuance of a writ. Then what is this? Is he going to tomorrow? Just for example, they out there or my private secretary out here, they do not inform me, or this office the registry do not inform me that in another case I have stayed it, but I have passed an order. It's a judicial order passed on 10/8 for issuance of a writ and to submit a report. So in this execution case, either the lawyer was a mistake, who should have known that there is already a proceedings under Order 9 Rule 13 where there is a stay, and this having not been brought to the notice of that court. It is that person's mistake, not his mistake.
Page 110, third paragraph. I thought kindly have a look.
Yes.
PW7, so-and-so himself stated that, perhaps this will assist you, stated in his evidence that since last 2 years, he was working in execution branch in the establishment of Munship number 1 in addition to his assigned duty of miscase and money suit assistant, etc. Writ in so-and-so has been prepared by him on submission of the same by the learned counsel, learned lawyer for the DH on 5/8/2011, and he endorsed in the said writ for execution of the decree by deploying police force and
because the order which had been passed by the learned court could not have been stay of the decree. Kindly see what order he has passed.
Yes,
Execution of the ex parte decree in so and so is stayed. Okay. But there is an execution proceedings. What do you stay? You stay the decree.
Yes.
In that execution proceeding, because there is an execution proceedings must have been going on. Now, this judge out there, he does not write it properly. He exercises the power under Order 41 Rule 5(2) and does this. And it is his duty, therefore, to say that the judgment and decree passed in so-and-so is stayed, or the execution proceedings must have started, must have been stayed. He does not do that. This very judge issues a writ. What is this person going to do? It's a ministerial stuff. Absolute handedness. When is your appeal? That. Before the Elad. We set aside this thing. This is no fault of him. We set aside this thing, it will help you out. No fault. Unless you take action against that judge. That is why I asked you, what action has he taken? Because he cannot take any action because it is his own order, he has committed a contempt. And what is the evidence of that judge? He must have been there. Huh? What is this? Or is that judge who decided it? You never know. Huh?
Petition.
10? What did you say? PW1 was the municipal so and so, so and so. And in
The
case of
plaintiff
Aya, in the court of Aya, during the tenure of his leader, predecessor, the proceeding was stayed by the Honorable High Court in so and so, and the stay order was subsequently vacated by an order passed in so and so. And on Iman, the decree holder filed a petition before him for proceeding with the execution, and on the strength of the aforesaid order, and on that basis, he reissued the writ of possession on so and so. In the meantime, one of the defendants, so and so, namely so and so, filed a petition before the court for setting aside the ex parte decree dated so and so passed in here. The said petition was registered as Miss Case, subsequently renumbered as Miss Case number Iman on the event of transfer of the year to the Munsif number 2. On Iman, he passed an order in Miss Case number Yes, staying the execution of the ex parte decree which was put into execution in so and so. When he passed the order dated so and so, in so and reissued the writ in the so Iman, and the order in so and so was not placed by him before him. So and so was the dealing assistant in execution case as so at that relevant point of time, and it is the duty of the incumbent to see all the orders passed in any execution or miscase, and also to bring it to the notice of any stay order was pending in such case. But for reasons known as so, he did not bring it to the notice. Then it is.
Evidence of DW7, that perhaps Lordship would like to see 110 down below, my lord. Cross what he said.
Yes.
Last paragraph up to page 111.
What is that?
Page 110, last paragraph, my lord, down below.
No, this I have read it.
Yes, ma'am.
I've read it. You see, you have to understand that this person will not know. You have stated the judgmental decree. This court should have known it. Is it the duty of the lawyer to produce it? Have you taken any action, disciplinary action against the lawyer?
Court. Am I to remember all the decree I have passed or all the stay order I have passed? That is perhaps is the question, my lord. If I have passed, my lord, say for example, in a week, I have passed 100 stay orders. Am I required to memorize all those orders, or it is the
No,
responsibility of the employee?
no, Mr. Counsel. Kindly appreciate. A decree has been passed in the suit. The trial court and the executing court is one and the same. You have to appreciate that. The trial court and the executing court is one and the same. Now, what happens out here, the basis on which the trial court and the executing court has been made one and the same is so that there is no confusion later on, because he knows what decree he has passed. Now, what has happened here? He passes an order of stay in the proceeding which is pending before him.
The question is whether that order was before him or not at that point of time.
So
that
it is therefore, and thereupon,
it's to be there.
you see, you have to understand. Just for example, I pass an order. Let us assume that I have passed many stay orders. I have passed an order of stay somewhere. It has gone out there, stay is continuing. On the other hand, in another matter, which is connected, I don't remember. I may not remember. I pass an order that go for execution. Okay. Is that the officer out there or the ministry staff? Is it the responsibility of him to come before this court to me and say, kindly rectify your judicial order? No, he cannot do that. It's
Council.
for the council to do. They should have come up and look here that this has happened. It may be a case of restitution. He may ask for restitution that when there is a state, it could not have happened. But how is he responsible that too when there is a subsequent order where writ has been issued and directing compliance? Kindly see. A writ has been issued and directing compliance to submit a report. And accordingly, it has been decreed. So how this person can be held to a mistake? Very difficult.
Because if we go by the show cause notice, the specific allegation against him was that he, in collusion with the decree holder of the title suit number so and so, suppressed the stay order dated so and so obtained by the judgment.
How will he know? How will he know that there is a collusion? That fact is not proved anywhere. Neither paragraph page 110 or 111 says that there is a collusion.
Yes, my lord.
There is a collusion. The only allegation which is being proved is that he himself stated
Yes.
that I saw this order, but I made a mistake in not, because there was no mention in respect to that particular execution case. If you see order 41 rule 5, what is state? The execution proceedings is state.
Yes, yes,
Isn't it?
correct.
This court very well knew that he was executing it. And then when that application filed under order 9/13, then they must have asked, you cannot pass a stay order in that application under order 9/13. You have to move an application under order 21 rules 26. This is how it happens. This cannot be the ground. Malice in law. Understood. If the High Court's order was not brought to the attention of him, just for example, the High Court passes a stay. Now, what happens? They don't communicate. They
the
don't
same court.
communicate to that court. Therefore, when I pass an order, therefore, you see, I direct the registry to communicate.
Yes.
The reason is very specific, so that there's a duty imposed upon the registry to communicate so that the suit can proceed. Sometimes what
Parties
happens, there is a
don't-
stay.
yes.
A stay is proceeding. The petitioner out here moves this case before this court. Other side is not present. I
Yes.
dismiss his petition, but the stay is going on. He is not going to go and intimate the court, look here, this has happened. He would
Correct.
not.
Correct.
So therefore, it is the duty of the court also direct the registry to communicate this order.
Correct.
This is how it is done, because it is the court who has to do it. Merely because now the judge concerned was in embarrassment, having granted a stay and then granted an execution, the petitioner is that person concerned.
Perhaps, my lord, it was also his duty. I am not saying how much mistake he has committed, but there was some, because he having seen the paper, I'm not saying it's his, he has to bring it, but it was also part of his duty. He having seen the thing, he could have,
Just tell me one thing.
that is what. my
No,
lord,
no,
it
let me,
transferred from
let,
the
let
inquiry
me,
report.
let me give you another example. This is an order passed on 10/8/2011,
Yes.
where the issue was, there was a reissuance of a writ. Okay? Then, when he starts to take steps, writ has been issued, the court has to sign.
Yes.
Okay. The court first passes this order and then it goes for reissuance. The writ has to be signed by the court.
Yes.
When the court signs this order or passes this order, can this person come out here and say, look here, you have made this mistake?
mistake is not there. If you look.
No, I'm asking you.
If I sincerely read this last paragraph, it doesn't say that, my lord, he has to dictate the honorable judge. It says, but from the evidence of the said delinquent employee himself, it appears that writ in so-and-so has been prepared by him so-and-so, following the last order dated 3/8 in so-and-so, after 2-3 days from so-and-so, but before 10/8/2011, he has gone through the case record of so-and-so 36/11 and found that there was a stay order, but there is no mention of any title execution case number in the said stay order. After going through the stay order pass in so-and-so, he did not approach the learned Munshi for clarification as to which so-and-so, so-and-so. So I'm not saying that he has done some serious misconduct, but some, perhaps they follow a procedure in their office, or so that's why my lordship, the penalty imposed was not a major penalty.
Major, reduction in salary is major. It could have been a censure at best.
So 7(4), one major penalty, and under subsection 7(2), one minor penalty under one head. They have compounded in a compounded way.
Page 123. Reduction to a lower time scale under rule 7(4).
123. Accordingly, Muhammad Sanania Chaudhry LD is reduced to the lower time scale of pay from death to death for a period of 3 years, with further direction that he will not earn.
No, tell me, when was the execution done? On 11/8? What is the date of execution? 10/8.
Death has already been executed on.
In petition for recalling of the writ as per the order dated 3/8/2011, Perus so-and-so and Iman call for a report, fix so-and-so for report and objection to the petition if any, let this order be shown to the learned advocate for the decree holder. Later on, seen petition number so-and-so filed by judgment under year for restoration of miscase as before. What is the miscase? So it was done, and why didn't the court stay on that date? The court could have stayed the execution. The execution done. What is happening to the execution proceedings now?
Execution was done. Just with regard to a stop and penalty. Execution was done.
You have got the possession. That person? Was there any restoration of possession filed?
No,
Let us see the records of execution case number 6. Is it pending? And what happened to the civil Nazir?
he was also imposed.
Penalty. No, yes, Nazir is different. We do one thing. Next time, next date we allow your petition. I'm satisfied completely. And no case.
Need a record. Perhaps
Record of what?
the departmental proceedings.
Produce it.
Perhaps that will give some.
You may have, but if this is the issue out there,
Yes.
very difficult.
Also will.
Produce the records.
Yes, sir.
The matter having been heard at length, comma, list the matter on 7th of August 2025 at 2 p.m. Full stop. Mr. H.K. Das shall produce the records of the departmental proceedings on the next date.
Much.
Yes, anybody interested in doing any hearing? What matter is that?
2018 matter, the driver, selection of driver challenging the appointment.
Gotta stay.
The
2018 is the fiscal year. What is the ground?
ground, P4 grounds mainly issue is he has not qualified because of that at that time of filing the application, he was not eligible.
Huh?
He was not eligible at the time of submission of the application advertisement.
He was not eligible. Why?
Because of that section 4.2 he has to be so 20 years is necessary for getting the professional driving license.
My goodness.
Yes, fine.
Did he have a professional driving license or not?
No. Actually, there's no rule in the respect of professional driver, transport and non-transport. And transport is not there. Admitted facts.
So?
So, he cannot be allowed to.
Where is the advertisement?
Yes, please kindly see. Please. Annexer 1, Sorry. And annexer 4, page 18, Applications are
To possess
invited.
a valid professional driving license.
Professional driving license, and date is 23/12/2013.
What is that 2312?
For the submission of the application invited till 5 p.m. of 23/12/2030 Monday. For citizens, so
5 p.m.
Yes, my lord.
And then?
At that moment, my lord, is the last date of submission 23/12/2003, my lord. 13, my lord. He has not, my lord.
Then?
And my lord, please kindly see. I am selected at serial number 6, my lord. He was selected serial number 5, my lord.
Serial number?
5, my lord. My lord, please kindly see page 21, annexer 7, my lord. This is
You are serial number 6.
my name is serial number Mohesh Hazarika.
I'm average obtained in driving test 27.67.
It was reserved.
My lord?
It was reserved.
No, my lord. Actually, I am SC candidate, but there is no any reservation, my lord.
Okay.
But my lord, respond number, my lord, serial number 5.
Ah.
It got obtained in, my lord, 22.67. I am getting 27.67. But interview is concerned, I am got only 333, but he has 8.58, 8.25, my lord. So thereby he has selected, my lord. On the basis of my lord interview, my lord viva, my lord. And if I am going to calculate it, the average in driving test, I am serial number 4, my lord. But getting a serial number 4, but they did not consider, my lord.
And when was the selection done?
Election was done, my lord, as per my lord,
2015.
my lord.
Why have you filed in 2018?
Because of that, I was 2 times I have RTI application of file. They did not give me.
No.
Your lordship,
No case. I'm not going to interfere with these type of cases.
because of that, my lord, I am, but thereafter I am collected from, they did not give me intention. They are third time they given, my lord, High Court's given, my lord.
Division bench may help you. I am not going to help.
If he is not eligible, affidavit in also admitted that he is not there, my lord. That
We can relax it.
and there is the interim order also.
In time for what?
Your lordship go first order, my lord. by
My
the-
order?
Yes.
I never passed such orders.
Yes, your lordship. Last
Where?
20, so many orders are there, pardon, thereafter, my lord, now is coming.
I said pardon.
No, other courts are there, my lord.
Other courts.
And so many directions are also there to giving affidavit as well as my lord.
Can't help it. I don't know the touch. This type of matter. Not
And
defined in the
is-
Motor Vehicle Act.
His date of birth is also manipulated in the record of the driving license.
Ah.
And I file an application, my lord, RTI, my lord.
Subject to meet the outcome.
Yes.
No, you filed so late. Can't help.
Our first RTI application was on file on my lord 5 to 2016. They
On
did
the
not.
ground of delay and dismissal.
And my lord 12th August 2016. They also don't get.
Mr.
give in
Bora,
on
I'm
20
telling you, I'm person having worked out there for such a long time, I'm not going to touch it. Now the question is dismissal in 10 minutes or 5 minutes? Heard Mr. N. Bora, the learned counsel appearing on behalf of the petitioner.
But one thing is that as a driver, my lord, last 18 from 2018, so many orders are there by the honorable court, and thereafter they file an additional affidavit. Therefore, additional affidavit. But now your lordship says that the due to my lord, long my lord, due to my lord time, your lordship. So my lord,
3 years.
already to admit the petition, my lord.
3 years. 3 years. I'm not concerned about what happened.
I was earlier, I filed a petition that was withdrawn by the that was withdrawn due to non-submission of the documents. My lord, they are stating in my lord petition.
Heard Mr. N. Bora, the learned counsel appearing on behalf of the petitioner. Ms. S. Sharma appears on behalf of the respondent number 1 and 2. And Mr. UAP Ador appears on behalf of the respondent number 3. And Ms. So-and-so appears for the respondent number 4.
My lord, para 19 you also consider, my lord. Para 19 in my petition.
The petitioner herein have assailed the appointment of the respondent number 3 in the post of the driver pursuant to a selection process initiated by the Guwahati High Court. You didn't also have a professional license?
Professional, there is no rule. There's an affidavit filed by transport department.
No, you also didn't have a professional license.
There is no rule in professional, but transport and non-transport. And other five also transport.
No. There's a professional license is there.
But
That license which
affidavit,
is
ma'am.
there, which is professional, is given for 3 years, isn't it, madam? But you give a professional license for 3 years. See, whenever we have a driver, earlier, because I remember my driver used to get his driving license renewed every 3 years, whereas our driving license, which is non-professional, would go for 10 years. 10 years or 15 years, our normal licenses. But it is only in professional you have these 3 years. There is a professional. That is why at that point of time it must have been there. Yes, because they used to have this license and you have to renew every 3 years, isn't it? That is, I have seen that professional license on my feet. Because, and they have to pay because for driving a taxi, you require that license. Now they may have mentioned is that transport and non-transport. Because at that point of time, because we are concerned in 2013, professional license was the concept out there. Maybe now they have transport, non-transport. Because a non-transport can only drive a private car or on one's own car. Because then these are all various issues which arise in the Motor Vehicles Act. Because he does not have that license. Driver may not have a license as regards a transport vehicle. There might be many of them who do not have that. That is one of the conditions which is being taken, that he cannot drive that vehicle as a driver.
License, my lord, all other five also, well, all are in transport, my lord. There is no any professional driving license rules also not there. My driving license, your lordship pays 17, my lord. This is the transport. Please make IG pay 17, my lord. And elite till transport 7 at 2000 so and so, and with effect from 3 to 2000 so and so.
So what is your basis of your challenge?
My conviction is that the only transport cannot. As per rule, my lord, 4 my lord, 2 my lord. My lord specifically mentioned that my lord in the order, my lord rule, my lord. Subject to the provision section 18, no person under the age of 20 years shall drive a transport vehicle in public place. We are on, all are into a 10, we are applied on 10 as a transport. And my lord, he has an LMB on a light motor vehicle. Because of that, he has not, at the time of submission of the application, he has not 20 years, man. And motor vehicle 2000, my lord, all there is no any about the professional meaning of the professional driving license. Nothing in it. All are transport and
You see this driving license, kindly come to page 28. Date of approval 16. Okay. Now this is issued duplicate having old validity, non-transport, so and so 232. This is for non-transport.
Yes.
But for transport, it is just for 3 years, you see?
Yes.
This is the professional license. So he had the professional license.
Not is got professional license. He is with effect from 24.
You have not challenged this license somewhere? Have you challenged this license? Mr. Counsel, have you challenged this license? Then
But his selection is illegal, my lord.
it's okay.
Nice one, my lord.
Mr. Yeah.
Yes, my lord, date of last application 23/12/2013. And he has got, my lord, in the, so he has completed 15/1/2014, my lord. And transport vehicle would effect on 24/1/2014.
The petitioner herein have a sale they taken.
And my lord, regarding your lordship.
Hey, Mr. Bora, take your seat. The challenge made to the appointment of the petitioner, of the respondent, number 3, is on the ground that the license of the petitioner, of the respondent number 3, was not a valid license in terms with Section 4(2) of the Motor Vehicles Act 1988. Which stipulates that no person under the age of 20 years shall drive a transport vehicle in any public place. It was mentioned that the private respondent would have been 20 years only on 15/1/2014. And the last date for submission of the application was on 23/12/2013, on which date the private respondent was not eligible to be entitled to a entitled to drive a transport vehicle. Taking into account the above case of the petitioner, this court finds it relevant to take note of that an advertisement was issued on 9/12/2013 for filling up of the post of 5 posts of Barkhandas (driver) in the principal seat of the Guwahati High Court. The eligibility condition is that a candidate should have a minimum educational qualification of class 8 standard and should possess a valid professional driving license. It is relevant to take note of from the affidavit filed by the respondent number 4 that the Central Motor Vehicle Rules 1988, 89, or the Motor Vehicles Act 1988, or the Central Motor Vehicle Rules 1989 do not conceive of a professional driving license. What is conceived of is a transport license and a non-transport license. Therefore, the very term in the advertisement of having a professional driving license was ambiguous. And as such, none of the candidates had a professional driving license. This court finds it pertinent to take note of the petitioner, along with 7 others, participated. How many? Along with that 16 candidates participated in the test in the selection process. The private respondent was at serial number 5, whereas the petitioner was at serial number 6. Pursuant thereto, on 5/2/2015, the petitioner, the select list was published, wherein the petitioner's name was shown in the waiting list at serial number 1, whereas the private respondent was amongst the selected candidates. Full stop. It is relevant to take note of that the petitioner thereupon filed a writ petition challenging the appointment of the private respondent, the selection of the private respondent. By filing a petition which was registered and numbered as 3097/17, which was filed on 4/12/2017. But without it being registered, the said petition was withdrawn, and subsequently, the present writ petition was filed on 6/2/2018. Full stop. The question arises as to whether this court, whether any interference is called for to the appointment, to the selection of the petitioner, of the respondent, private respondent, and his appointment. It has been mentioned in the affidavit so filed by the private respondent that he was appointed on 19/3/2015 after carrying out the necessary verification of his driving license and obtaining the report from the office of the DTO Dibrugarh on 26/2/2015. It surprises this court that the petitioner herein have not assailed the appointment order. The record further reveals from the affidavit filed by the respondent number 4, as already stated here in above, that there is no concept of a professional driving license. The respondent number 1 had also filed an affidavit in opposition. That the word professional license have been used in the advertisement on the ground that in various judicial pronouncements the term professional driving license have been mentioned. In the backdrop of the above, this court have heard the learned counsels appearing on behalf of the parties and also peruse the materials on record. First, the petitioner herein was one of the candidates who applied, and he had due notice that on 5/2/2015, the petitioner was not selected but was put in the waiting list. First, the petitioner, for reasons best known, did not challenge the appointment till filing of the writ petition, the first filing of a writ petition before the registry in the year in the month of December 2017, and thereupon filing the present writ petition in the month of March 2018. First, on this ground, it is the opinion of this court that the petitioner the instant writ petitions is required to be dismissed on the grounds of delay and laches. First, this court further finds it relevant to take note of the allegations made in the submissions so made by the learned counsel appearing on behalf of the petitioner in respect to Rule 4(2) of the Motor Vehicles Act 1988, which stipulates that no person under the age of 20 years shall drive a transport vehicle. It is relevant to take note of that driving a transport vehicle is not an eligibility criteria mentioned in the advertisement. What was mentioned in the advertisement was having a professional driving license, which is an ambiguous term not found either in the Motor Vehicles Act 1988 or even in the Central Motor Vehicle Rules 1989. Considering the above, this court finds no merit in the instant petition for which the writ petition stands dismissed.